Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you. Good morning. Welcome, everybody, to this session of the Appeals Court on May 8, 2025 in courtroom 4, the Hale courtroom. There's one argument in the other courtroom, so I hope you're not here for that. We have 7 cases on for today, and they're all civil cases, which is unusual. Usually we have a mix of criminal and civil, so we have a lot on today. We have read your briefs, we've read the materials, so we're very familiar with the cases, and you can jump right into your arguments without a lot of introductory stuff. Our materials are on these tablets, so if you see us looking at our iPads, it's not because we're lamenting the Celtics game last night. We're actually looking at the case materials. And rules are simple. Each side gets 15 minutes. There's no rebuttal, so try and anticipate the appellee's argument. And oh, I forgot to introduce ourselves. I'm Justice Massing. To my right is Justice Hand. To my left is Justice Hershfang, and we'll be your panel today. So, calling the first case, it's Newman versus Middlesex County House of Corrections, 24P667. Mr. Dennehy.
May it please the court, I'd like to take the easiest part first. There was a negligence claim and an emotional distress claim. The plaintiff in the case properly pled those claims, and there was evidence to support those claims. There were 2 separate entities described in the complaint. One was the use of an ERC chair, it's a restraint chair. There's actually videos that were produced in discovery which show
do we have those videos in the record before us? I didn't see them. I was looking for them.
They weren't in the record per se. The ERC chair itself is in the record, and it's mentioned in the briefing in the lower court.
Okay, so we can't, though, we can't review the videos.
Actually, this court can do whatever it wants. I've had an appeals court order things from the trial court to please its curiosity. So if you
so you didn't think it was necessary for us to see it, because I mean you didn't put it into the record, right?
I didn't put it into the record in the appendix. It's a complicated type of thing, but it's based on there were no interrogatories propounded in this case. So the allegation is he's in a chair, and at the time it's not medically disputed, his back was deteriorating, his spine was deteriorating. And so he's in a chair, restrained in the chair, and in the video they loosen you can even see they loosen the restraints. And there is in the record a deposition of one of the corrections officers where I go over the video with him, and behind the restraint chair there's a restraint bed. And I said, with his back, he's complaining of back pain, that's why they loosened the restraints. Couldn't they have put him in the bed? And he said yes. So that's a sure case of negligence. Maybe it doesn't arise to battery.
Who was that corrections officer?
Multiple ones said it.
Right, but you're mentioning particular deposition testimony of a particular person, right?
I just know his name is Sorrow, I think, began with an S.
And was the complaint ever amended to include his name specifically?
No, so what I'm trying to say is in a negligence claim, you don't have, it's not a 1983 claim, so you don't have to name the officer individually for negligence. So I'm starting out what I say is the easy part is I think that negligence is pled against the Commonwealth. It's not an individual battery claim. It's just a state tort-based claim of negligence.
Well, if you assume for the moment, which I think maybe is only for a moment, that the Commonwealth has some respondeat superior or agency negligence liability here, isn't that only through the actions of individual employees?
Right, but there's nothing in the law that says you have to individually name that person. They don't have to be a named defendant. The Commonwealth is a named defendant. So under negligence, this idea of naming, the case where they talk about naming the corrections officers was a 1983 civil rights claim, and it was battery. And so if someone batters someone, they're stepping outside the scope of their employment, and you have to name them individually. That's what the case is saying. That's what.
So did you have a mass torts claim count in your complaint?
There's a common law claim for negligence and a common law claim for emotional distress.
But you're suing the Commonwealth for negligence, so don't you have to go through the MTCA to do that? They can't be sued for intentional acts, but they can be, but they must be sued for negligent acts. And you're saying that it's the Commonwealth as the defendant here. So I think isn't the procedure the Tort Claims Act?
I've sued the Commonwealth for negligence in this type of environment before, and I have never been, no one's ever tried to defend by saying that I had to exercise the right somewhere else. I mean.
No presentment letter necessary?
Well, the defendant's not an employee, he's just a civilian. At the time, he's coming in to be incarcerated, but.
The plaintiff?
Right. But it's just.
Okay, so you have a negligence claim against the Commonwealth that you bring as a pure negligence claim?
Right, pure negligence and no emotional distress, also common law claims, and I believe there's enough evidence to those claims to survive, regardless of the bigger issue about, and I'm allowed to alternatively plead. So even with the battery and the takedown, so, you could say that that is a 1983 battery claim and the individuals have to be sued, but you could also say, well, maybe they were negligent, and a jury could decide which. So there's two separate instances, one's the chair, one's the takedown. Either one of those could be a result of negligence, a common law negligence, common law emotional distress. In regard to the bigger issue of whether the officers are named, the situation arises from the defendant, or the plaintiff in this case. He was a criminal defendant, but he's the plaintiff in this case. His girlfriend was assaulted and battered, and he got into a fight with the guy that hit his girlfriend, and he was arrested and he was brought to a correctional facility. He was injured in this fight. He's taken to the HSU, that's their infirmary, and he's being looked over there. And the nurse decides to release him to go into the facility. And he says, I still have some pain, I'm not comfortable with, and my ankle hurts, I want you to examine me more. And she says, no, you're done. And then they call in corrections officers into the HSU, and they take him down. He alleges that they drove a knee into his back and that there was battery involved with that takedown. And then he was immediately taken from there to solitary confinement. And there's a movement card in the record that shows him going to solitary confinement. So there's also in the record their procedures, and they have a written protocol. If there's a use of force, there has to be an incident report. And they have incident reports in this record, in this case, for anything from this plaintiff biting himself to, just cursing at a corrections officer. But this takedown, there's no incident report. And this is a situation where someone comes off the street, has never seen these corrections officers before. It's just a rush, they take him down, then they take him off, and he doesn't know who was on top of him. He can't say in good faith.
So you mentioned earlier that the plaintiff hadn't propounded any interrogatories in this case. Do you remember that correctly?
I said the defendant had.
Oh, the defendant, okay. I thought I saw.
That's them, right? We're talking about, okay. Did the plaintiff?
Right.
Did the plaintiff propound interrogatories?
I believe we issued some basic discovery, and
interrogatories?
And we did. I know I deposed everybody on. I issued some basic interrogatories, and there was another claim against the nurse that settled. So.
Right. I guess what I'm getting at more specifically is, was there ever an interrogatory issued to the defendant Commonwealth and the defendant institution that said something like, identify the corrections officers who were called to the infirmary at the date and time to respond to the situation with your client?
I can't recall that because I was stonewalled at every turn, so I deposed numerous officers, and I took a corporate B6, 30B6 deposition, and everybody feigned ignorance about this event. Nobody knows about it. Nobody knows anything about it. And what's telling about this is that...
I'm sorry, just before you, I want to be clear. So we don't know if you asked in an interrogatory to name the officers involved, or you did and they said, we don't know?
I don't recall if I used an interrogatory. I'm a skilled lawyer with thousands of cases of experience. I do recall that I used depositions, and I took a 30B6 deposition, and I specifically asked, who responded to that scene. Multiple depositions under oath, and they all said, we don't know. We don't know anything about this incident, and the reason why they didn't know anything about it was because there's no incident report. And what I find curious about this is that the video of the plaintiff in this case, when he's in the ERC, there's a video of it's in the ERC chair, it's in the HSU. There's cameras there. I got some camera footage, but I don't have camera footage of this takedown. But we know it happened. We know there was an incident because he was immediately taken to solitary confinement. And that's like sometimes when you do something wrong, you don't always cover your tracks. And it's very telling that there's a movement card. There was an incident. There was a use of force. There should have been an incident report. So when Judge Young wrote his case, and it's been well argued in this court and in the trial court nearby that a district court case like that is not binding on Massachusetts state courts. It can be instructive, but it's not binding. But I think what's interesting is that's a different set of facts, a different set of circumstances, and Judge Young said, even in that decision, where justice, he says the case should be dismissed if you can't name the officers, but he said where justice requires, you shouldn't dismiss the case. And in this instant, how can somebody in this circumstance name who took them down when there's no incident report, when there's supposed to be an incident report?
Can we go back for a minute to the deposition you have of the corporate designee? We don't have the Schedules A and B that identify the areas in which the deponent was expected to be knowledgeable. Is that, or was identified as being knowledgeable, do we?
She didn't know, she didn't answer affirmatively to anything.
Okay, but just as far as identifying what it was that she was there to testify about, we don't have that documentation, do we?
We don't, but I mean, the standard one would be about the facts and circumstances in the complaint is a standard question, and she was asked that. She didn't know anything about this incident. No one knows anything about this incident.
Okay.
There's nothing in the record about it.
There was at some place, I believe, in that deposition, some agreement to provide the names of some additional people. Did that happen?
There was an agreement to clarify what's in the video, and
Right.
Honestly, as an officer of the court, I don't really see the video as showing battery. I see it as showing negligence.
But it showed people who were present, correct?
Showed people present. There was their uniform badge area was gray in the videos.
Okay.
So for that.
If I recall correctly, the judge said that the faces of those people were visible. Am I right about that?
That's correct. But I got those videos after the close of discovery.
But was there any request that you made specific to that video to identify the people in it?
For the video for that, no, because at that point I did my own analysis and I made the conclusion that that was more of a negligence claim than a battery claim, and I felt like I wasn't going to, I honestly didn't think I was going to lose on summary judgment, and I thought I was going to try the case more on the takedown as a 1983 claim and that the ERC claim was negligence.
And we have just,
And it's overlapping damages.
you have video of the ERC claim, but not of the takedown.
Right.
Is there anything in the record or anything, obviously not asking for attorney-client confidences here, but did you have reason to believe that the people who were there during the ERC incident were a different team from the people who were there during the takedown?
If you ask me, from everything, the gravamen and everything I look at, the people in the video during the ERC chair weren't necessarily the people during the takedown. It was a whole different shift, way different periods of time, just months
Okay.
apart, so.
Okay.
So that's why you didn't name, I think Sauer, you mentioned before, as a defendant in the 1983 claims, because you didn't think he was there at that point,
Right.
or she.
And then I've briefed the issue on qualified immunity, that I don't think it applies here. And I think a lot of this, I cited to a Taylor case. It's a federal case out of New Hampshire, but it deals with 1983 claims. And a lot of what we're dealing with, I feel, are within the purview of a jury and a fact finder to decide. Okay.
I've got one more question. The 1983 claim, I'm a little confused on whether you're proceeding as a Fourth Amendment claim or an Eighth Amendment claim.
I think it's pled generally as both, but it never got narrowed down because I never got a set of interrogatories to clarify that claim. And it got dismissed on summary judgment, so I haven't gone to a pretrial memo right before trial to supplement where we're at with that. But I think it's just it's pled broadly.
All right, thank you. We'll hear from the Commonwealth or the sheriff. I'm not sure which one.
Both.
Okay.
Good morning, members of the panel. My name is Stephen Pfaff. I'm representing the defendants in this case, the John Doe defendants, the Middlesex House of Correction, and the Commonwealth of Massachusetts. This is a 5-year-old case. The plaintiff had ample opportunity to move to amend his complaint to name individuals if he wanted to do that. He never did it. So the summary judgment judge got it right that all civil rights counts, all negligence counts against all defendants should be dismissed because of the plaintiff's failure to identify those John defendants up until the time of the summary judgment motion. His solution to that, by the way, was also rejected by the court. And his solution to that was he was going to bring in 100 witnesses from the Middlesex House of Correction in court and have the plaintiff, hopefully, identify those individuals. Now, think about that for a minute. If, in fact, he was allowed to do that, that would mean the John Doe defendants had no opportunity at all to file a motion to dismiss to the complaint. Or if I decided not to file a motion to dismiss to answer the complaint, they wouldn't be subjected to any affirmative defenses. They would be subjected to no discovery, and they would not be allowed, I would not be allowed to file a dispositive motion under Rule 56. So the judge
I understand that's a bad solution, but he tried some other solutions. I mean, we don't have the schedules for the 30B6 in the record, but the witness is singularly unhelpful about that. Do you know whether any video was produced? I don't know. Have you apprised yourself of the dates of the videos? I did not. Are you aware the plaintiff has made an allegation there was an unlawful takedown in the HSU? I'm not aware. So, that was the person that you offered up as being the most knowledgeable.
I did, and there was no objection from the plaintiff on that. The plaintiff never moved to file a motion to compel with respect to the individual that I produced under the 30B6.
I know, but your obligation is to produce a competent witness.
I did, but as the Schedule A's and B's are not in the record by way of the deposition notice for the 30B6 individual, but it covered the gamut, not only of the day in question, but also policies and procedures and the like. So it could have been multiple individuals that I would have had to have produced.
But that's not unusual, right? I mean,
No, it's not
happens.
unusual. No, I produced this one, and the plaintiff didn't take it any further with respect to, I think as I recall it, the 30B6 was suspended And I told the plaintiff, if there are other individuals you wish to have here, I may be able to identify them. And he took it no further, and that was it. And there's nothing in the record otherwise to show that.
Why isn't there any video of the incident?
Well, the incident, there is a video of the ERC, as Justice Massing suggested, but there was no incident that anybody can figure out that occurred in his cell. This is a situation in which he was...
At the HSU. In the HSU.
In the HSU, right. This is the situation in which he was brought in. He was arrested, allegedly injured, I believe, as a result of that incident that took place outside of the jail, and brought in, and almost on the day that he was brought in, he was taken to the ERC. That's where the video is, but there's nothing else other than that. That was produced. I cited federal cases with respect to not naming a defendant in a case. I cited First Circuit cases of Figueroa, Lucas versus the City of Boston, Stratton versus the City of Boston, Panate. They all go to the heart of the matter about not identifying John Does, and you can't go forward if you can't identify them after discovery at the summary judgment motion. And this is what happened in this case. And that applies to the negligence cases as well. Justice Hershfang indicated earlier that you can, only the employer is negligent under Chapter 258, but have to be negligence through the action of some individuals. And if you can't identify those individuals, then you can't hold the Commonwealth or the Middlesex House of Correction. They're one and the same for the purposes of this suit. You can't hold them liable under Chapter 258. I indicated what the prejudice to the defendants would be if the solution that the plaintiff proposed was allowed by the court to bring in 100 individuals and have them identified by the plaintiff as possible individuals involved in this incident. I don't think I need to reiterate what the prejudice there would be to the defendants. There's also the issue here.
I'm sorry, I want to go back on, so there's no video of the takedown, but for the purposes of summary judgment, we have to assume there was a takedown, right? I mean, the undisputed facts, officers came into the infirmary, need him in the back, guards rushed him and need him in the back and sent him to the hole. Those are in the summary judgment undisputed facts, right?
Well, I don't think those are the findings of the facts by the court. I think he's referring to the allegations by the plaintiff.
On a summary judgment motion, this is the plaintiff's, I'm reading from the plaintiff's response to the Commonwealth Statement of Undisputed Facts. So it looks like it's your statement of undisputed fact that the plaintiff alleges that the officers came into the infirmary. But for summary judgment, don't we have to take that as true?
You do.
Okay. So we have to assume there was a takedown, right? An incident.
But if you can't identify the individuals who were involved in that incident, you can't survive summary judgment, especially where you haven't done the things that the trial judge said you should have done. You should have filed a motion to compel. You should have moved to extend the discovery deadline, which, by the way, was extended jointly with my assent on a couple of occasions due to plaintiff's counsel's illness. Yet the plaintiff never moved at any point in time unilaterally to file a motion to extend the discovery deadline. So all of these attributes, all of these factors are available for the plaintiff to follow, and he didn't do it. And then at the last minute, he suggested at summary judgment, oral argument, let's bring in 100 people to determine if the plaintiff can identify them, and you can't do that. And the case law is very clear on that. If the panel has no further questions.
Just one more. I've got one more. The Attorney Dennehy suggested at the outset that the easiest claim is the negligence claim against the Commonwealth, where you don't need a named individual. How do you respond to that?
Oh, you need to identify the individuals involved in order to hold the employer liable in a situation like this. You can't say they're John Does and then never identify them. We have to be able to see, as the employer, if you will, who those individuals were on a particular date. And if you can't identify them, then you're out of luck. You can't hold the employer liable.
I understand what you're saying, but aren't you in the best position, much better position than him to identify who those people were?
I think the plaintiff is the person who is best choice to identify the individuals. I can supply the information about, and I did, I supplied the log about everybody who was present over a 24-hour period. The plaintiff took the deposition of 3 of those officers. None of those officers could remember anything involving the plaintiff, but for, I believe, him being strapped to the restraint chair on another occasion, not the one in question here. So I supplied all the information to the plaintiff. He had 5 years to amend the complaint, to change the names of the John Does to actual individuals, and he never did it.
Okay.
Anything else? Thank you, members of the panel.
Okay, the case is submitted. Just one more thing. Congratulations on your daughter's graduation. I hope you make your flight. I hope you don't have to go through Newark. And you have the case.
Philadelphia, and I appreciate your courts accommodating us. Thank you.
Okay. The next 2 cases are paired, but we're taking them one at a time. And so they both have the same name, so you can identify them by their docket number. The first one we're hearing is 24P872, Champa versus Durham and others.
If you have not signed in, please sign in if you're arguing today. Thank you.
So I believe this is Mr. Champa's appeal.
Yes, Your Honor.
Okay, and we'll hear from counsel.
May it please the court, Your Honors. Thank you for the opportunity to argue before you today. David Luck, along with my colleagues Garrett Lee and Dylan Rosina, and our client Christopher Chiampa, has also joined us here today. So 2 issues that we raise in our amended principal brief and our reply brief, and I understand I have limited time. I will attempt to cover all of this, but as a colleague recently reminded me, there's a great paraphrase from Thurgood Marshall that says, long after the arguments are over, your brief remains. So if I don't cover anything, rest assured, Your Honors, we have covered everything in our initial brief as well as our reply brief. Brief point to begin with, I do want to correct, there was a date that we got wrong regarding the year at pages 25 and 26 of our amended initial brief, as well as page 22 of our reply brief. That was defendant Jesus Landaverde's police interview 4 days after the accident. The accident here obviously occurred on May 22nd of 2019. We got that right. However, my mistake, I put that the police interview occurred 4 days later on May 26th of 2024. Obviously, that's also 2019, so I wanted to correct that. So, with regard to both the voir dire issue and the manifest weight issue, we have a common core of what should be considered undisputed facts, and that is significant. I want to run through those facts quickly because they pertain to both issues. So, this starts with an admission during the defendant's opening statement. So, in their answer brief, their counsel takes issue with the assertion that there was overwhelming evidence here regarding Jesus Landaverde's decision as a professional truck driver who was trained never to do this, to wave Ms. Durham, the co-defendant, out into traffic on Medford Mall on May 22nd of 2019. However, sorry, Your Honor.
Doesn't that statement go directly to a contested issue that was presented to the jury and decided against your client, namely the meaning of the wave? You say wave into traffic. How do you see that articulation as consistent with the jury's verdict of no liability for the driver and Cisco?
Sure, Your Honor. So the reason why it's uncontested and there isn't a dispute of fact on that point is in negligence law, on almost every issue, you have to judge it from an objective perspective. Both Mr. Landaverde and Kenneth Wayne Belcher, the corporate representative for defendant Cisco, acknowledged that you cannot read the mind of someone you are signaling into traffic, which is why drivers are trained not to do it. And then consistent with that, these are not my words, on May 8th of 2024, during opening statements at transcript page 201, defense counsel chose to tell this jury at the beginning of the trial, there's not going to be any dispute regarding the fact that a wave occurred here, and there's not going to be any dispute regarding the significance of the wave. He said that after plaintiff's lead counsel, attorney Keith Mitnick, went through over dozens of pages during the plaintiff's opening and recounted the wave, recounted that the jury was going to hear evidence from Officer Brooks, who was the investigating police officer, that that was an objective indication that it was safe for Ms. Durham to proceed into traffic. Defense counsel then chose to tell the jury that that significance was undisputed and that the fact of the wave was undisputed. Respectfully, defense counsel wanted to have his cake and eat it too. He wanted to tell the jury, in order to garner credibility, that there was no dispute here regarding the wave, but then he wanted to fight with us regarding the voir dire question, regarding the verbiage that was used, which was both waving and signaling. However, the trial court, in the statement of the case, used the verb wave, used the verb signal, and then the question that attorney Mitnick wanted to pose, there were two iterations. The first iteration of that question, and this is a paraphrase, but it was along the lines of, I can give you the statement of the case without hearing anything further, without hearing any of the evidence. I'd like to know whether any member of the jury, simply under any circumstances, can never agree with a liability theory predicated upon waving. The judge then said, that is too close to the facts of the case, therefore I'm not going to allow it. Attorney Mitnick then said, well, in that event, Your Honor, I have a rephrase. And Attorney Mitnick rephrased it as follows. If you know that this case involves waving by the Cisco driver, does that create bias? That question, under amended Superior Court Rule 6, which was adopted in 2017 by the Supreme Judicial Court and the Superior Court, predicated upon the legislature's 2014 adoption of MGL Chapter 234A, Section 67A and D, was not something that asked a hypothetical. It didn't ask the jury to pre-commit to a certain verdict, and it didn't consist of any argument. And in addition, it used the same verbiage that the court used in the statement of the case, as well as the same verbiage that defense counsel used during opening statements to tell the jury that there wasn't going to be any dispute in this case regarding the fact of the wave or the significance of the wave. I want to go through the facts very quickly, and I see I only have about 9.5 minutes remaining, but significant piece of evidence here is the police crash report authored by Officer Brooks. Officer Brooks goes through in detail regarding the circumstances of this crash. He points out you have someone coming out from the Harvard Vanguard Hospital parking garage at a 60 to 80 degree angle with potentially obstructive view to the right based upon the B pillar of Mr. M's Toyota Tacoma, as well as multiple street signs and lights. And based upon that, he says speed is not a factor. She relied upon the motion coming from Jesus Landaverde
well,
to pull out.
But she testified that she didn't rely on the motion, right? She testified that she, or didn't rely solely on the motion. She testified that she also looked, that she understood it was her obligation to look.
She did acknowledge it was her obligation to look, and our theory here, to be clear, was never that Ms. Durham was not negligent. Our theory here, consistent with the jury instructions that this court gave. The court did not give an instruction on superseding or intervening cause. Defense counsel asked for that. It was rejected. The court instead gave a jury instruction regarding the fact that there can be multiple but-for causes of an accident. And actually, and this is important, Your Honor, I do want to stress this fact. At pages 8 through 35 of our amended initial brief, as well as pages 22 through 26 of our reply brief, we go through in painstaking detail all of Ms. Durham's relevant testimony. And we did that because we suspected that Cisco and Landaverde, in their answer brief, would paraphrase, would summarize, would cherry pick. I would submit to your honors, it is not a fair characterization of BRIANNA Durham's testimony in this case that she did not rely upon the wave. She reiterated over and over and over again that she, unlike Jesus Landaverde, readily accepted her responsibility for this accident, but that she also relied upon the superior vantage point of Cisco's professional truck driver, who was trained never to wave out into traffic because only police do that and it can cause accidents, was seated up high in the middle lane, had an unobstructed view out of his driver's side rear view mirror, and heard the approaching Harley-Davidson motorcycle that our client was riding on a one-way street. There was only one direction from which this motorcycle could have approached, given that it's a one-way street running from south to north, Medford Mall, in front of the Harvard Vanguard parking garage, and Jesus Landaverde readily admitted, eventually, after dissembling regarding his deposition testimony and answers to interrogatories, he admitted both in his May 26, 2019 police interview with Officer Brooks, and Officer Brooks confirmed that Jesus Landaverde is a fluent English speaker, had no difficulty with English, and at trial that he in fact waved Ms. Durham out. The only thing that Jesus Landaverde disputed at trial was whether Ms. Durham should have been able to rely upon her understanding of that wave. He said, well, it wasn't my intention to indicate to her that it was safe to proceed without looking. However, as Officer Brooks testified repeatedly, that type of wave is an objective indication that it is safe to a driver to proceed, and Officer Brooks, and this is contrary to what is said in the answer brief, no one other than Officer Brooks said this was a contributing factor. That wasn't a statement of counsel, that wasn't a statement of some other witness. Officer Brooks, who was responsible for investigating this accident, said unequivocally over defense counsel's objection at trial, and the objection was overruled, that this wave was a contributing factor to this accident. And I understand that in Massachusetts, it is rare, indeed one of the cases, which is, I believe, West Oliver Trip Company, authored by Justice Cass, says that holding that the trial court's ruling on a manifest weight motion is an abuse of discretion is something that is extremely rare, and he analogizes it to a snowstorm in mid-May. I would submit to your honors, this is that rare case where it is appropriate to find an abuse of discretion because, again, superseding an intervening cause was not an issue in this case. Instead, but-for causation for multiple accident participants was the basis of the jury instructions. And then we have the decisions I want to talk about, Woods versus O'Neill. So Woods versus O'Neill, which was authored by Justice Kafker, who's now on the Supreme Judicial Court. It's a 2002 decision of this court, 54 Mass App Court 768. In that decision, the court held that it is an appropriate liability theory under the circumstances of that case to allow a waiving claim to go to the jury. In that situation, it was a 14-year-old girl who was attempting to cross a 4-lane road, and you had a driver for Massachusetts utility company who waved her across, and she's struck by a car. The court recounts that there are decisions from multiple different states, and that some states recognize liability as to waving children out. Other states recognize children and adult liability for waving out, and some states reject adults' ability to rely upon waving out. However, you also have the Doyle versus...
This case did go to the jury, right?
It did go to the jury.
So I guess I'm just kind of not following what Woods says that's useful to you.
Well, it's useful in the sense that it discusses the fact that this is a viable liability theory, and then you look at...
And the judge didn't find otherwise, right, here?
Correct. However, amended Superior Court Rule 6 says that when the judge allows attorney-conducted voir dire, you are supposed to be able to ask, inter alia, questions going to the legal issues in the case. Whether a jury can recognize a liability theory that exists under Massachusetts law regarding waving into traffic is a legal issue that should have been inquired to here. And the reason I say that, Your Honor, go ahead.
So you're saying, you're answering a question that I hadn't asked you, but I meant to, which is that you think Woods is your best case to support the proposition that's an abuse of discretion not to allow discussion, I won't say attorney voir dire, but, you know, allow exploration of a legal theory during voir dire.
Except that case doesn't deal with voir dire. The reason Woods is a good case for us is because it recognizes the liability theory. The case law that I would rely upon for purposes of allowing questions with regard to legal theories that are central to the case comes from two sources. Number one, Massachusetts criminal appeals decisions from this court and from the SJC that have allowed the prosecution for the Commonwealth to ask questions with regard to whether jurors can accept circumstantial evidence, DNA lacking, fingerprints lacking, and yet convict. And that brings me to those cases. I want to address one additional correction. So after the briefing closed in this case, the Supreme Judicial Court affirmed this court's decision in Commonwealth versus Montgomery, which is cited on page 51 of our amended initial brief. However, the court held that the phrasing of the voir dire question that occurred there was improper because it sought a commitment to convict. And in this case, Attorney Mitnick did not seek a commitment to rule in favor of the plaintiff. Instead, both formulations of his question were phrased in terms of, regardless of what the evidence is, before you hear any of it, would some of you just say, under no circumstances will I even recognize that Massachusetts allows waiving as a liability theory? That is the antithesis of asking for a commitment to a particular verdict. Rather, sorry, Justice Hand, you have a question?
I do. Assuming we agreed with you on that, would you have to show us that there was prejudice to your client as a result of the failure to give that instruction?
Yes, Your Honor. So your case law does require a demonstration of prejudice, but what I would point to on that is, and this is at pages 40 through 45 of our amended initial brief. So states that have decades, if not over 100 years in the case of California, of experience with attorney-conducted voir dire, what they have held is that when the question is appropriate, but the trial judge decides not to allow the question, we have no way of presuming that there is a lack of prejudice if it's a central legal theory in the case, because we don't know how any of the prospective jurors would have responded. Therefore, we have no idea how counsel would have exercised their peremptory challenges or their for-cause challenges. I have 20 seconds left, but briefly, the cases are Boyles versus Dillard from the Florida 1st District Court of Appeal, Ingracia versus State from Florida's 4th District Court of Appeal, Cram versus Stockton from the California Court of Appeals 1913 decision, question regarding the last clear chance doctrine, which is a legal liability theory, and Duffy versus Carroll from the Connecticut Supreme Court 1950, and Lamb versus Burns 1987 decision from the Connecticut Supreme Court. And then finally, Your Honors, I see my time is very much at the end, but pages 51 through 52, actually 55 of our amended initial brief, their catalogs are the appeals court decisions and SJC decisions regarding voir dire in criminal cases where central legal theories, bless you, Your Honor, are allowed to be asked about in criminal cases. Superior Court Rule 6 says it applies equally to criminal and civil cases. So if Massachusetts allows questions regarding central legal liability theories in criminal cases, that should also apply in civil cases. Thank you, Your Honors, for the time, for all the reasons explained in our briefing. We respectfully request...
One second before
Yes,
you
sir.
sit down, one more question. I mean, you're characterizing the voir dire question as a question about the legal issue, which is permitted under the Superior Court rule. But the Superior Court rule, on the other hand, doesn't allow hypotheticals that are close or specific to the facts. And couldn't the judge, in his discretion, have determined that the question was more going to the facts than going to the law?
Except, Your Honor, how Attorney Mitnick responded and how he phrased the initial question. He said, regardless of what the evidence shows, without knowing the facts, if you simply hear legal liability theory predicated upon waiving, are any of you saying, I simply can't be fair, I reject that theory? And then when he rephrased the question, he just said, knowing that there's an allegation of waiving, without any more, do any of you hold bias? So I would submit under amended Superior Court Rule 6, that's not a factual hypothetical. And also under Ross versus Dietrich, this court has said that there's not a per se bar to asking questions in voir dire that are predicated upon the facts of the case. So for all these reasons, Your Honors, we respectfully request that you reverse for a new trial in this case. Thank you for your time. We appreciate it.
Thank you.
Thank you, Your Honors.
We'll hear from counsel for the defendants.
Good morning, Your Honors. Mark Lavoie on behalf of the defendants Jesus Landaverde, Cisco Boston, and Cisco LLC. The first thing I wanted to talk about were the guiding principles which I think should control this court's view of this case. The first being that the jury is the pillar of the justice system, and nullifying a verdict is a matter of utmost judicial circumspection, as this court as the Supreme Judicial Court noted in Cahaley v. Benistar. The trial judge, as the fact finder, the jury is the fact finder, not the judge. He's not the 13th juror. He can't displace the jury because he just disagrees with it, and he can only set aside a verdict if he believes the jury failed to exercise honest and reasonable judgment in accordance with the controlling principles of law. And here, the judge denied the motions for a new trial on both grounds, finding that there was the evidence was sufficient for the verdict in favor of the defendants, and finding that there was no prejudice in not allowing the plaintiff's attorney to ask that one question which you've just heard a long discussion of. And the court's standard of review, your standard of review, as you know, is whether or not Judge Christopher Barry Smith abused his discretion in making the decisions, those two decisions he made. In abuse of discretion, the definition, it occurs only when a judge makes a clear error of judgment, weighing the factors relevant to the decision such that the decision falls outside the reasonable range of alternatives. And that's
Could I interrupt you and ask you, with respect to the jury instruction, why wasn't one of the two formulations that Mr. Mitnick used a proper question about a legal concept versus a factual question?
Well, Judge, we had discussed this, and you're asking me to answer for Judge Smith, Barry Smith, but we had discussed this in pre-impanelment. The judge had said, I want to say something to the jurors about what this case is about, and all you've said is negligence and, nobody's at fault, basically very bland. And so he came up with a proposal, and it's in the record appendix on pages 89 to 91. And on page 89, he describes it for us, and he says, you'll also hear that Mr. Landaverde was not involved in the collision, his truck was not involved in the collision, but that he was a driver of the truck, and that it is alleged that there was a gesture to Ms. Durham with respect to entering the roadway or something like that. So that was his first suggestion to us. And then there was some back and forth, and then he came up with a second idea to try to do it because Attorney Gurley had a concern about how it was phrased. And he then said on record appendix page 91, lines 3 through 6, Mr. Landaverde, you will hear, was a driver of a truck for Cisco in the center lane, and that as a defendant in this case, because of an allegation of a gesture made to Ms. Durham. And Ms. Gurley says, thank you, Your Honor, that's good. And then he asked me, and I say, yes. The court says, that's pretty basic. And then I said to him this, on lines 11 through 14, you had initially referenced to enter the roadway, and I would object to that. So if you say it just as you just said it, that's fine. This is all about messaging, Your Honor. Messaging what the plaintiffs want to message and what we, as the defendants, were trying to message. What I said in my opening, it's true, I said a gesture, a motion or wave isn't disputed. When I said wave, I didn't say wave out. The testimony of Mr. Landaverde is he's two hands on the wheel, I see you, I acknowledge you. That was his testimony, that was his wave. It was not, come on out, you're safe to come out, it's all clear. The whole argument in the beginning of the case about this gesture or wave went to the police reports.
I'm sorry, I'm going to stop you. I thought you were going to circle back around to answer Justice Hand's question, which was, what was wrong with the way Mitnick phrased it? And I think it was the second time where something about very blandly, why would you be biased by, evidence of a waive?
So I apologize. I didn't get your question. I was, if you look at the colloquy on his question, in his question, and this was the major issue that I had, the record doesn't reflect that I objected, but I did. I stood up before the judge said something as he was asking the question, and so the question's on Record Appendix 177, and it says, within this is his question. He says, and within the statement of the case, the judge was telling you, remember, he talked about the allegation the Cisco driver waved or signaled to the other defendant. I cannot go any further than that. That's as far as we can go. This is his question that he's saying. But then he decides to go further. And he says, but I do want to ask you, how many of you would say, just hearing that, I'm over here, I don't think you have much of a case, because I don't see how someone could be responsible, no matter what the rest of the evidence, so he's talking about evidence, what the rest of the evidence shows for waving someone out.
But how is that not similar to, if not the same as, at least similar to, a prosecutor asking a jury before a criminal trial, could circumstantial evidence ever be enough?
It's very different, Your Honor. Circumstantial evidence is a legal doctrine. It's a legal...
Well, so is liability.
Liability is, but not evidence about how that liability happened. He's getting directly into the whole crux of the case, and that's what we say in the colloquy. He's now dropping the seeds, planting the seeds of his case, waving out. We're waving out. That's what the Cisco driver did. That's what the other driver claims she relied on. But the police report, back to the police report if I may, that says clearly she understood what this was, this signal, this gesture, this motion, this wave was to allow her in. I will allow you in. It's as if somebody flashes headlights and says, I will allow you in. She did not tell three interviews with police officers within a week of the accident, 2 that day, 1 a week later with her lawyer and with her husband to this same police department. Each one of them, she says this, I understood the gesture, the motion, which is what the police report called it, a motion. I understood it to mean he would allow me in. She gets up on the stand and then says, I thought it was all clear, and then obviously I start cross-examining her about all that. This is critical evidence. It's not a legal theory. The legal theory is, as Ms. Gurley asked the jury after, is can you find, are you comfortable? Do you have a bias against finding an individual responsible, even though he is he's a causal actor, even though he didn't physically be involved in the accident? Can someone who's not physically involved in the accident still be liable? Could they be a cause? Nobody raised their hand. The reason why this isn't prejudice is because the judge had already, the judge's questions had already covered it. There were 2 jurors who raised their hand and claimed they did have a bias, and we cite to those jurors in our brief, and their juror numbers...
Those were the motorcycle riders, right?
No, no. Well, yes, there were for motorcycle riders. I apologize, Your Honor. But there were also to this question about
One of them was favorable to the plaintiff, one of them is favorable to the defendant.
Precisely. And so, in other words, the judge's question originally had covered this. He felt, as I did, it was way too close to the evidence, and what was happening was, I thought, 3 things directly in violation of Rule 6, E3. He was asking for specific opinion, not about liability, but about evidence, as his question shows. He was fact-specific. He was also looking for a prejudgment on that evidence. You think I don't have a case. He's trying to see if somebody thinks that. Are they prejudging it? That's small Roman 2 of 6E3. Small Roman 1 is stay away from specific facts. Small Roman 3 is no planting seeds. You can't argue your case. And that's precisely what he did. He says, I can't go any further, and then he goes further.
So can on one of the jurors, I guess it's the one that was favorable to the defendant, that was removed for cause. The Cisco driver made a gesture that constituted negligence. That's silly, right? He said that gestures are negligence. That's silly. I mean, isn't that a bias that the plaintiff should be able to get to ask about?
Well, he did get it. I mean, the judge found it. The judge's question explored that. After the question was stricken, not allowed, the plaintiff was allowed to ask a follow-up. Is there any reason, from all you've heard, for a bias? And this is now after 30 minutes of this. He's been asking questions about bias and whatnot. The judge clearly, within his discretion, and the judge does have discretion to even decide if there is panel voir dire, and quite frankly, this is what I said to him beforehand. I've done this for 37 years. I don't like panel voir dire for this very reason, that the panel can get prejudiced by questions that are improper.
Can I ask you, just help me visualize, because what in the courtroom was the attorney voir dire, was that to like the panel, the veneer sitting in the box, or was that to individuals who are up at sidebar?
It was to individuals sitting in the box, and then we have the panel, the rest of the potential panel back. So this is an exercise, and I've done voir dire a number of different ways, and I always tell the judges, I prefer that the judge ask the questions because the judge controls it, and then the attorneys can either ask the judge or the judge lets the attorneys ask at sidebar the questions, so we don't have...
You've lost that battle, but...
Well, some say the Superior Court judges are coming back to it, and quite frankly, this is why. Because...
the attorney voir dire was in front of... Not
everyone.
Just it was for the whole panel. Okay.
And this is an exercise where we get everything covered with these questions. You can read it. It was 2 days worth over Morgan and Morgan, about large jury verdicts. I mean, this is a process intended, I believe, to change the culture. And so I would ask that the court look at this very seriously. Judge Christopher Barry Smith took it very seriously and handled it properly. And he didn't give us all favorable decisions on the defendant's part. We argued that in essence, this case is an assumption of a gratuitously assumed duty and should be subject to gross negligence. He thought it was a great argument, but didn't let us have that. So the point being, he was very fair and balanced. And in this in particular, this is no prejudice to the plaintiff. This issue was certainly vetted by the judge. We have evidence of 2 jurors deciding that they had a bias, one in each way, as you say, Justice Massing, and there's no harm. The harm was the potential steps that this attorney, and if you look at the quotes, right after he said it, I was struggling last night how to ask this question. And he knew he got it wrong, that the judge objected to it, that I objected to it. And so we would ask that there's no prejudice here, that the court find that the voir dire was properly conducted. As I was saying, the judge has under the rules, they decide the scope of the voir dire, the manner in which it's done, the time allowed to do it. It's all within their discretion.
So I want to ask you a question that Justice Hand asked Attorney Luck, which is, in the Commonwealth, if we determined that it was an abuse of discretion to not allow that question, we still have to ask whether there was prejudice?
You're saying if there...
If we were to say that
Yes,
it was an abuse
yes.
of discretion, but then we still have to look to say that it was...
Yes, and our position obviously is there is no prejudice, as shown by the actual vetting of the panel each day. And so on the 2 days, we went back at this again, and the judge provides the same opening presentation to the panel, which includes this gesture wave issue. So it's out on the table. Everybody knows that they're not, this is not one car hits another. So there's no question at all. If you'd like to hear, I have 32 seconds, the weight of the
Actually,
evidence.
no, you're going up. They took a little bit extra too, but you're going up, and you're arguing the next case too, right? Are you arguing the next case as well?
If we have another set of arguments, sure, I'm happy to. I had interpreted it to mean there was literally just one argument. But if there are two, sure, I'll be back and we can discuss it again.
Attorney Gurley's going to get up for the next one. Okay.
Thank you, Your Honor.
Okay. Thank you. Nice job, both of you, for your clients. And the case is submitted, but we have a second one. So go ahead. We'll have. Which is same title, which I apologize for the pronunciation. It's CIAMPA versus Durham. This time it's Durham's appeal, and it's 24P948.
Thank you, members of the panel. May it please the court, Allison Gurley for the appellant, BRIANNA Durham. Ms. Durham contends that the trial judge abused his discretion in denying her motion for a new trial, where the verdict finding no negligence against Mr. Landaverde was against the manifest weight of the evidence. And I'm going to start with an argument made by Cisco in their opposing brief that contends that Ms. Durham doesn't have standing to contest the verdict that was against her for negligence, but not against Mr. Landaverde. And I would say that in Massachusetts, under the contribution amongst joint tortfeasors statute, we have statutory right of contribution amongst joint tortfeasors, even though judgment may or may not have been recovered against any or all of them. And that's a statutory that there shall be a right of contribution, and that's regardless of whether there's a cross-claim by Ms. Durham against Mr. Landaverde. So it's our position that the verdict was against the manifest weight of the evidence. I understand that
Can I go back just for a second? I'm not understanding exactly how that translates into your having appellate rights with respect to issues that deal with another party.
Because so the finding, the verdict in favor of Cisco and against Ms. Durham essentially finds that there isn't even 1% liability on Mr. Landaverde, and therefore Ms. Durham stands in the place of the entire being responsible for the entire $19 million verdict. And it's our position that she has a right of contribution against Cisco and Mr. Landaverde for their 1% or whatever their percentage is of negligence. And she would still be able to file within a year a claim for contribution against them as a joint tortfeasor. And the statute, the contribution amongst joint tortfeasors statute, obviates the need to bring a cross-claim against a co-defendant because there's automatic contribution amongst joint tortfeasors under the law.
Do you have a case that says what you're saying?
I don't, but I did review the cases cited by Cisco, and it's my understanding that one of them was from another jurisdiction, and one of them was before the contribution amongst joint tortfeasors statute, and that was enacted. It's my practice not to bring cross claims against co-defendants because that statute is automatically provides the right of contribution. So I understand that Ms. Durham throughout the trial, contended that Mr. Landaverde was negligent. There was no question that that was our position, and that we contend that the verdict was against the weight of the evidence and not finding him at least 1%, given all the evidence that was presented.
So there was no option on looking at the verdict for the jury to find him 1% or any percent. It was either liable or not, right?
That's right. That's right. It was a yes or no question on the question of negligence. However, in practice, if his negligence in any way contributed or was a but-for cause of this accident, which Ms. Durham testified over and over again, but for the wave, she would not have exited the driveway that day, and the accident would have been avoided, then, even if his negligence is slight in comparison to hers, the jury may still say yes to that question. But they were not instructed whatsoever about 1%. Those are my words, and that wasn't an issue that was put before the jury.
The best they could get it they found him not negligent at all. The next question was, if he was negligent, was that a cause?
That's correct. That's correct. That would be the next question. And we don't typically assign percentages amongst joint tortfeasors. The only time there's a percentage involved on the verdict slip is typically when there's a claim of comparative negligence against the plaintiff, and here that the judge didn't allow any comparative negligence question.
I'm sorry for being really slow this morning, but I'm having, if you could just explain to me, in light of the jury's answer no to the question, was defendant Jesus Landaverde negligent, how is he then a joint tortfeasor?
Well, it's our position that that verdict was against the manifest weight of the evidence. And I know that that Mr. Champa's counsel reviewed some of the evidence, but I would like to just go over a couple of things that I think were undisputed that were before the jury, and why it's our position that the jury was misled, swept away by bias or prejudice, or misunderstood the applicable law in rendering this verdict.
Okay, I just want to pause you before you do that with one more question. Assume for the moment that I agreed with you that it was against the manifest weight of the evidence and therefore somehow could disregard this check mark next to no. How is it that the right to contribution under the joint tortfeasor statute would also confer upon your client a right to appeal the jury's verdict as to someone against whom she had filed no claim?
Well, I think because we asked for a new trial, not only because that verdict was against the manifest weight of the evidence, but based on several other areas that we thought were prejudicial error. And I think in a new trial, that question would be asked of the jury again. And it's our contention that he is a joint tortfeasor and that the verdict is wrong. So maybe I'm reasoning it in a circular way, but...
Okay.
So the evidence that we found, or that we believe was overwhelming, was that Mr. Landaverde was a commercial driver. He had a higher vantage point. He had the large mirrors, the side mirrors. He admitted he had not checked his mirrors since he turned onto City Hall Mall. This was fully against his training as a CDL driver. It was against his training by Cisco. Cisco's safety director said it is dangerous to wave people because it can cause accidents. He admitted that Mr. Landaverde violated his training. He should have checked his mirrors in this circumstance. Most incredibly, Mr. Landaverde had his windows down and admitted he heard the approaching motorcycle. He admitted that regardless of understanding there were no words communicated, right? So he didn't know what...
He heard a motorcycle. He didn't hear an approaching. He said it could have come, he didn't know what direction it was coming from.
He did say that, but it is a one-way street with 3 lanes all going in the same direction. Traffic was completely backed up in front of him in all of the lanes, all the way up to the light. The only way that motorcycle could have been approached, there's no side streets. It's 3 lanes going all in the same direction. That motorcycle, I mean, he had his window open and it was literally coming from behind him and right alongside him.
In front of him, it was a light because there was another street, right?
Up ahead, yes.
Right.
Where we were stopped.
Didn't he say he couldn't tell if it was coming from behind him or maybe from another direction? In other words, it's not a road through the middle of the wilderness, right?
Correct. Correct. But where they were stopped in traffic and where this accident occurred was at a crosswalk around the middle of the block. The light was up ahead at the end of the block. So certainly, yes, I'm sure there could have been a motorcycle on the side street up ahead. But he did hear the motorcycle approaching. Admittedly, he said he did not know. He admitted that he did not communicate his intention by the wave to Ms. Durham, and that he had no way of reading her mind, of course, as to what she understood the wave to mean. But he also knew there was an open lane to his left. And I think that the trial judge struggled with this issue a lot, going back to the final trial conference, going back to the motions in limine, and almost daily we revisited this issue. The trial judge indicated many times that he was having trouble with this theory of liability, and that he almost felt as though Ms. Durham was trying to transfer her duty to Mr. Champa upon Mr. Landaverdi, and that's not at all what was happening. The duty of care of Mr. Landaverdi was to the public, to other members traveling in that open lane to his left, including Mr. Champa on his motorcycle. He knew that by waving someone who's poised at the exit of a driveway to cross, whether in front of him or into that lane, that she had to cross into an open lane of travel, a lane of which he had the better vantage point, a lane of which he admitted had he looked in his mirror, he would have seen the motorcycle. Had he looked in his mirror, he would have not motioned her. He admitted that under oath. Though his story changed many, many times, the wave was never in dispute, and the meaning of the wave, frankly, what Ms. Durham interpreted the meaning of the wave to be is more important than what Mr. Landaverdi meant by it. Because you can see in the video, and your honors do have the video of the accident, you can see her come to a stop at the edge of the roadway. You can see her pause for a moment, and then you can see her accelerate out of the parking lot. And she testified that having this wave from this commercial truck driver gave her the go-ahead. It gave her the all-clear in her mind that it was safe to proceed. So even though she testified that she looked to her right and did not see the motorcycle approaching, there's an urgency with which she exits the parking lot that day, and it does show that she relied on that wave, which is what her testimony was.
Was the important question, though, whether a reasonable person would have done so under those circumstances?
I think that the jury, so I think it was reasonable for her to rely on the wave given the position and the vantage point of the Cisco driver. She did say that she looked, she didn't see anyone. Whether it's reasonable or not to rely on the wave, it really depends on the circumstances at the moment, and I think the evidence was very clear that he was a commercial driver and he had a better vantage point of the street. She didn't hear or see the motorcycle. Obviously, she wouldn't have pulled out had she seen so.
Was she asked, did you hear the motorcycle? And she said, I didn't.
She was asked, and she never heard it. And she couldn't recall.
Were her windows up?
I was just going to say, I don't want to misspeak. I believe they were up, but I know it's in the transcript. And so I know that she didn't hear the motorcycle, but I can't recall specifically what the testimony was regarding the windows. There were also some arguments that we objected to regarding golden rule arguments. I did object when
You objected to a question that you say now is a golden rule argument, but you did not object to the closing argument, right?
Yeah, so it's interesting. Attorney Mitnick did object during the closing argument. It's a little bit, there were 7 attorneys in the courtroom at all times. It's a little bit nuanced whether or not to object during a closing, but when Attorney Mitnick did object and the judge said he would allow the question and then in fact apologized to the jury for the interruption, it was a choice not to object further during the closing argument.
We have a lot of cases on today, so I apologize if I got the wrong case, but didn't the judge say let's wait till the arguments and let's hear it all at sidebar at the end?
He overruled the objection. He said, I think there was a little colloquy between the judge and Attorney Mitnick as to whether, well, if I'm going to say that, in my closing, the jury should put themselves in my client's shoes, will that be, and I think the judge said, it's good for the goose, it's good for the gander, we'll let you both make the same arguments, but I'm overruling the argument. The part that I objected to was when Officer Brooks was asked whether he would cite a member of this jury for waving someone else out. I did object to it. That was overruled. It's textbook asking the members of the jury to put themselves in their shoes. It was argued, we all do this every day. It's a courtesy. It's not something that could never rise to the level of negligence. I think Attorney Lavoie said in his argument that is simply not the law, which isn't actually true. The law is that a driver has responsibility, whether waving or making a signal. They have the responsibility to do that reasonably, right, under the law of negligence. So there's a duty of care to anyone who might be affected by that wave. And Ms. Durham, in this case, reasonably interpreted that as an all clear. In other words, that lane to the left of the Cisco truck was clear. And to the extent that any rights were not preserved, I would say that this court can take notice on a survey of the whole case, sort of in hindsight, of any plain error that injuriously affected the substantial rights of the party. I would say it is an extreme injustice that this plaintiff amputee has a $19 million verdict that he will never see because this jury got the negligence finding wrong as to Mr. Landoverdi.
Okay, well, if you have nothing else, that's fine.
I don't.
I forgot to say at the beginning, there's no penalty for finishing early, so.
Okay, thank you.
Mr. Lavoie again?
Round two. So what I'd like to address is the idea that it was reasonable for the plaintiff to have relied on the wave. The plaintiff's, Ms. Durham's testimony that she relied on the wave and it was all clear. That was exposed. We exposed that through the police report, which she couldn't refute, that she never changed her story. She never went back and changed it. She said it 3 times. I understood it to mean he was allowing me in. The police officer who took it, Brooks, said, she never said to me all clear. She said, I understood he was allowing me in. Also, Ms. Durham says clearly in her testimony, I looked to my right after the wave or motion or signal. I looked to my right. That means I didn't rely on it. I looked myself to make sure. Sometimes she testified she looked twice. So her testimony was like a pendulum going back and forth.
Well, but I mean, that's not entirely fair in a world where there is contributory negligence, right? You can both rely on someone else and undertake to do your own investigation.
Sure, and so the jury weighed that, Your Honor. And the jury said, no chance is Mr. Landoverdi responsible for this. And it was exposed very simply when I asked, and Ms. Durham was a difficult witness. She was crying. She has 2 young children. Her husband's the veterans officer in town. Have to be careful with all that. But I did ask her, now, about your 2 children, when you're driving with them, do you ever rely on somebody else before you pull out? And she said, of course not. And that exposed the fallacy that in this time she relied on someone else. She knew it was her responsibility and she wasn't paying attention. And the clearest piece of evidence about that is the witness behind her, the last witness in the case, Cheryl McKenzie, who testifies, I'm behind her, I can see the motorcycle coming, I can hear the motorcycle coming, and as the brake lights go off, I say, what is she doing? If I didn't have another piece of evidence, an eyewitness saying they see it, they see what happens, and the accident happens, she wasn't paying attention. That's the cause of this accident. She removes her foot from the brake, from the gas, brake to the gas, and accelerates. At 14 miles an hour, she hits that motorcycle in 11 feet. The investigation, the officer, also a veteran, initially says, I questioned him on the speed of the vehicle. I can't say she was going anything other than 14. It wasn't fast. And then I said, well, could she have inched out? I don't know. I showed the video to him, and he finally admitted, yes, like the other 2 vehicles before her that came out and entered the roadway, they nudged out and went. If you watch the video, she shoots right out. So we have the video, we have her own admissions about what she should have done, we have the testimony of the eyewitness behind her, we have Officer Brooks asked by plaintiff's counsel acknowledging that the ultimate cause of the accident was Ms. Durham driving into the motorcycle, edging out and going. So it's clear, there's abundant evidence to support Mr. Landaverdi's and Cisco's position that they were not the cause of this accident. And that's what the jury found. And I told the jury, I asked the jury, I didn't tell them, I asked the jury at the time, we talked about this in voir dire, can you put your sympathy and emotion aside? We're asking you to do that now. Because it's clear that Mr. Champa had a significant injury. There's no question. That's not the case. The case is the cause of this accident was Ms. Durham. The jury looked at this fully. They had clear eyes when they made their decision. They had a lot of evidence supporting our position. The statements that Mr. Landaverdi heard a motorcycle, Judge Hershfang, you were absolutely correct. This was not out in the woods. The City Hall Mall is like a big U, and the cars, if you watch the video, come around and then come up the road. There's traffic coming from the right. There's traffic merging from the other side. What he said was, I didn't know where the sound was coming from. I don't know when I heard it in the sequence, but I know I heard it. And I went in my closing, also the whole thing about the sequence and timing, and plaintiff's counsel made this big presentation about, you knew for 10 seconds that this motorcycle was coming. No, not at all. Actually, if you back it out, the only evidence about the timing of the accident is basically it's 5 seconds between the time the motorcycle is seen at 177 feet and the time of the accident. And so in those 5 seconds, you have to have perception reaction time, as testified to by Officer Brooks. Perception reaction time is 1.5 seconds. So when she decides to go, she's perceived and reacted to a signal that's happened 1.5 seconds at least before. And then before that, the tractor-trailer driver has to perceive and react to coming to a stop. So really, he's starting to make that decision about 1 second, 0 seconds when that motorcycle is coming. So there's really no time. It's instantaneous. And the jury understood that, and they accepted it. I see silence. I'll rest on my briefs unless there are other questions from the court.
Seeing none?
Okay. Again, to just sum up, this really is a standard of abuse of discretion. Judge Christopher Barry Smith took all the evidence very seriously. The jury clearly took the evidence seriously. They didn't come back in 5 minutes after this thing went out. They sat with it long and hard, and they made a fair and correct decision. The evidence clearly supports it. And as to the allegations that I broke the golden rule, we strongly dispute that. It's set forth in our brief in response to Ms. Durham. We referred to the common sense of the jury and never once told them to get into the shoes of anyone.
Okay, thank you. The case is submitted. I mean, we also will take the facts, the briefs, both cases very seriously, and thank you for your arguments. The case is submitted. So normally we take a break after 3 cases, but since we have 7 cases today, we're going to hear the 4th case, but the folks from the second and third cases want to take this moment to leave, we'll give it a second. Okay, calling the next case, it's 24P960, DCF versus Mother. Are we missing somebody? I know, Mr. Katz, for the child, we have Mother's Council?
He's coming.
Okay, thank you. Okay, Attorney Penta.
Good morning, Your Honors, and may it please the Court. My name is Michael Penta, and I represent the appellant mother who is present here today. And we request this Court vacate the decree terminating her parental rights, and we remand with instructions for the Department to convene an updated ADA meeting per its policy.
Can I ask a question on the ADA policy? Can you
Yes.
point out to me where that issue, the DCF's compliance or noncompliance with the disability policy or the ADA was first raised?
I would love to get to that question, Your Honor. It was first raised, it's a much more complicated answer, if I may. It has been raised by the fact the department was well aware in 2018 that my client had, it was peppered throughout their records.
So if it's not talking about through the life of the case, and I understand that you're making that argument, is there a separate place where it's raised as a discrete issue?
I would submit to this Court that I was about to argue as part of my argument the importance and the recognition that the Department's 2022 disability policy should have not only in this case, but in all cases concerning a parent who has a known or obvious disability. Gregory was the guiding case in 2001 that held, although the federal government in its conclusions in its assessment.
And I'm sorry to interrupt you, but is the short answer that there isn't a specific place that it was raised?
Oh, it was raised, factually in this case it was raised in two instances.
Okay.
One throughout the case where my client asking for accommodations throughout the case, through department's knowledge of her developmental delays and cognitive limitations, but also during cross-examination of the social worker on their own disability policies and what has been done by the department with respect to their affirmative obligations under the disability policy. But I would also submit to this Court.
To beat the dead horse. I mean,
Yeah.
and I understand you think that the burden shouldn't be on your client to make requests, and that Gregory is perhaps bad law, but there was not a specific request. There was not a Rashida motion. There wasn't an abuse of discretion motion with respect to an ADA meeting or with respect to color coding or
Rewriting.
visual clues.
Yeah.
So I would submit to the Court that a parent's disability under the ADA is a sort of sui generis category under the reasonable efforts analysis. Reasonable efforts and ADA are not synonymous. A parent could ask for reasonable efforts because they need assistance getting rides to a visit. They need assistance with getting housing. Those aren't things that the ADA is implicated in. That's just the parents need the department's assistance, and the department is required to provide that. When the ADA is implicated, it casts on the department additional obligations. And I do submit to this Court that we do appreciate the past precedent, but the ADA disability policy has somewhat changed that. And because that wasn't the department waking up one morning and saying, oh, we need an ADA policy. It was forced down their throat by the federal government following examinations into allegations and complaints about systemic discrimination. And so this ADA policy is sort of derived from federal oversight. And it obligates
Just to put a period on the questions.
Yep.
There was no specific request. It should have been. You're saying the DCF should have realized it anyway.
Correct, and I would submit that their policy obligates them to. They have one of the requirements under the ADA policy, again, which was derived under federal oversight, and all the materials are in the addendum of my brief, is that the department was obligated to construct a notice, a very simple, plain language, 2-page notice that whenever a parent, this is directed by the federal government, this is a requirement under their policy, to hand that parent that notice that explains all of their rights under the ADA, it explains the department's obligations, and it explains to the parent how to raise a complaint to that When a department fails to do that, they should not be able to shield themselves from a parent and saying, they waived it because they didn't bring it up. Well, they didn't know about it because you failed to notify them. It's almost a due process issue, that they're not being, if a parent who has a, and I'm sorry if I'm, if I'm getting caught up, department's obligations don't trigger because of filing of a care and protection. This triggers at the very first moment they engage with a parent. So either the responsive worker or the ongoing social worker, who in this case is the same person, had an obligation during the first meeting to hand to my client a notice explaining her rights. I think the department should not be shielded down the road to say, well, they didn't raise it. Well, you didn't notify them of that. And therefore, I think when a department fails in that specific obligation, at a minimum, they lose the right to claim a parent waived their rights to that, especially if in a case like this, where it's been obvious throughout the duration of the case that the client suffered from a disability.
Assume for the moment that I agreed with you that the department should have done that. How is what you're arguing consistent with Gregory? I mean, we are bound by Supreme Judicial Court precedent.
All right, so Gregory is not incompatible with my argument. My argument is and again, it's not incompatible with Chad, and it's also not incompatible with the department's policy. When a parent has a known patent cognitive limitation, the department's policy requires them to provide notice. Under Gregory, a parent could have a latent defect. They could present well, they could have things that wouldn't be so obvious on the surface. They're not contained in depth in the department's records, as it is in this case. And therefore, that could be the exception. Now, maybe the exception in many cases may swallow the Gregory rule, but the Gregory rule is 25 years old. It was entered at a time before the department's policy was put into place. And the department's policy is a derivative of its failures as found by the federal government to accommodate parents with disabilities. They bought into the stigmas and the stereotypes. And by allowing them to escape their mandated responsibilities under the disability policy, simply acknowledging that they can continue on the behavior that the federal government held them accountable for. And I do submit that the federal government wasn't too kind to the holding in Gregory. Now, I know it's not this court's authority or ability to deal with Gregory in that respect, but certainly can acknowledge that the disability policy that was implemented just 2.5 years ago, imposes now affirmative obligations on the department to make certain steps towards a parent with a known disability and not continue to use Gregory as a shield and dismiss their policy.
What would the mother's requests have been in this case had she been provided the appropriate notice?
Well, so if she had, I can't answer if she provided the notice, but without the notice, the request that she requested was to have the department color code her service plan so that she could prioritize, because she gets overwhelmed with what am I supposed to do? It's almost paralysis by analysis. You have too much to do, where do I start? So it would have been helpful to have color-coded her action plan to say, well, do this. And then when we accomplish that, we'll move. This is the most important thing. And one of the most important things they did do, and I'll get into that, is the dual diagnosis program. That was the social worker's own testimony that if mom was engaged in a dual diagnosis program, we would consider her substantially compliant with her service plan. Well, she was on a 9-month waiting list. She was trying to engage in, back to your question, Justice Hand, is color-coding the service plan, simplifying the language with the assistance of her collaterals, escapes me, but they're in my brief, but the last one would be obviously assistance with getting into a dual diagnosis program because she was on a waiting list for 9 months. She was in a dual diagnosis program, as you recall.
The help of the department on that, or with the referral of the department to the group dual diagnosis program that was not.
So my client was very clear that she preferred one-on-one. Group programs were not her. Again, in my brief, and the timeline here is the department referred her to a group program. It wasn't suitable. She was referred to then a one-on-one program, but she was put on a waiting list, and eventually that program was unable to take her. She then, I believe, went through her physician, was enrolled in New Horizon, which was an acceptable dual diagnosis program because her therapist was trained in both. She was her therapist, not my client, not because she was non-compliant or non-engaged, just wasn't the right fit, so referred her to Riverside, where she basically toiled on a 9-10-month waiting list. I think at the time of trial, she was 10th in the waiting list. So she was willing to engage in the service. It was access that was being denied of her. And she did testify at trial that she was, and I think eloquently, despite all the other things that might have happened at trial, eloquently testified that what she was learning at New Horizons up to the point of her discharge. So, like in Chad, like Justice Dickoff holding is, we don't know that maybe on the surface that the facts of this case may lean towards the unfitness in the judge's decision, but we have the unknown because of the department's lack of follow-through with its own disability policy, with the department's failure to accommodate mother's reasonable requests, with the department's failure to assist her with getting her into a dual diagnosis program while she waited for 9 months. I mean, these are the things that the department was brought to task for by the federal government.
But fairly was the decision that the judge made does not, I have questions about whether the decision that the judge made rested on the mother's ability to prioritize her action plan items or her ability to understand what the action plan required, which was the point of the simplification of the language. That does leave the question about the dual diagnosis program, but there was effort made. The question is whether those were reasonable efforts in some point rather than perfect efforts. So I'm struggling a little bit with why that's the dispositive issue.
Sure. So on two fronts of that, Your Honor. First, I would submit that reasonable efforts doesn't exist in a vacuum, especially in a termination of parental rights analysis. For example, the judge, when we look at the General 10, Section 3C, 14 factors, a number of them are predicated on whether the parent was offered or received services. Of the 7 that the judge relied on in terminating my client's rights, 4 of them require as a predicate whether she received adequate services and assistance. So I would submit that when the department fails to follow its own policy and assist a disabled parent with access and services, it's legal error for the judge to then rely upon that failure or ignore it at least or dismiss it in assessing whether that parent's rights should be terminated. But I know there was another part to your question, and
No, I think that answers where I was going.
Can you help me there? As I understand the record, that your client did have one or many parent aides throughout the life of her involvement with DCF. You seem to suggest that that doesn't count towards reasonable efforts?
I'm not saying it doesn't count, Your Honor, but when the department's disability policy is implicated, it requires a deeper dive into what the department fulfilled in the reasonable efforts arena. So if the department may have provided routine services to a parent, whether those routine services were appropriate or we don't necessarily know. I know the parenting aides, I know worked very hard with my client. I know that she was doing a lot of things behind the scenes in terms of preparation for her visitations with the parenting aide. The parenting aide actually was supervising at one point her visitation. And I'm not discounting that no efforts means reasonable efforts. You could provide efforts and it might not be reasonable or it might not be adequate. And that's really the focus is the department. I'm not chastising the department for saying they did nothing. What I'm saying is that they were aware of my client's disability, provided routine services, relied on other agencies to provide services that weren't parent-related, like the Department of Developmental Services, for example. My client, as the judge found, was compliant and consistently engaged in DDS, but they're not DCF. They're a different agency, tasked with different responsibilities to their clientele. And working with DDS is not a crutch or an excuse for the department to not do what it is responsible for doing under its own policy. So what I submit to this court, and again, I think this is the second part of the question I was going to answer, Justice Hand, is that the judge in this case, although she made detailed findings of facts and conclusions of law, conclusion 27, her reasonable efforts analysis, completely ignores this department's policy. And I do submit to this court that the bar is seeking guidance from the appellate court. So what exactly is the department's responsibility? Is it just another policy that is just aspirational in goals and can be ignored? Is it have teeth?
This goes back to the very beginning of the argument. I mean, now you're saying that, the judge didn't address the policy, but was the policy raised before the judge? Like, or were you, yeah.
In cross-examination, I mean,
There was a single question.
I'm sorry?
There was a single question on cross-examination in a huge transcript. You asked social worker Cameron, are you aware of the policy? No. That's not the same as saying, Judge, you have to grapple with the fact that DCF has a policy and that they're not, and how does this fit in? I mean, that wasn't in the case.
Right, and I think in this particular case, there's two parts. There's the procedural waiver argument, and then there's the substantive issue of whether the policy was raised. As a procedural and legal requirement, the judge is always required to consider whether the department made reasonable efforts. That's Walth, Rashida, and, they're just quoting the statute, that the department is obligated to determine whether the department made reasonable efforts. Here, they're raising an argument that mother waived that argument by not raising it sooner or until trial. I disagree that that's when it was raised. I think it was a theme throughout the case, as Chad has espoused. But it's also an obligation for the department to provide notice. And again, I submit that at a minimum, the department's failure to do the simple task of handing a parent a piece of paper, which is something they do customarily every time, shaken baby syndrome, SIDS, they hand a lot over. I've already said it, I see I'm out of time. So if there's no further questions, I'll rest on my brief.
Okay, thank you. We'll hear from the department.
Good morning or afternoon, not sure which at this
Good
point.
morning.
Tracy Corral for the Department of Children and Families. I'm here this morning to request that this court affirm the lower court's determination that mother was unfit and that she was likely to remain so, that termination was in the best interest of the children, and that the department made reasonable efforts in this case. I will start where you ended with a question about Gregory. Gregory is still good law in the Commonwealth, and this issue was not raised in the lower court. There was no motion for abuse of discretion, there was no Rashida motion, and there were no objections to the department's permanency plans.
Can I just pause you there for a second? This is not the first case that, at least that I've heard, that in which a parent is seeking to challenge Gregory. Is any of those has the SJC taken FAR or DAR on any post-Gregory case, if you're aware?
I am not aware of any cases at this point, Your Honor. And I would just like to
So how do you respond to the Chad argument? I mean,
Yes.
that the mother's disabilities were a theme throughout the case. They were readily known to DCF from the beginning.
I'm not going to deny that the mother's disabilities were a theme throughout both cases, both involving the sister as well as the daughter and son here. What I will say is that because we lack any kind of motion practice below, we don't know. Their record is silent on whether or not the department gave mother the disability notice. The record is silent on whether, actually the record is not silent on whether there was an Americans with Disabilities Act meeting. There was some brief testimony at trial. Social worker Cameron did say that before she assumed responsibility for the case, there had been a Americans with Disabilities Act in January. I can't recall the year at this moment. However, there was a meeting, and so she did know there was a meeting. She just couldn't remember the results of that meeting, and she could not remember the disability policy, unfortunately.
Her testimony on that whole area is not very good for the department.
Agree.
I mean, she says she doesn't, if there were recommendations, she didn't remember them and she didn't implement them, and that she wasn't familiar with the policy. I mean, doesn't that suggest that that main social worker wasn't
The testimony was unfortunate. I'm not going to deny that. However, the very good thing is that our social workers have supervisors and managers. And so what I would like to do is direct Your Honor's attention to the actual substance of what occurred in this case. And the department is required under its disability the disability policy to, if they know some behavior that's consistent with what they believe might be a disability, to speak to the parent to make and offer the parent reasonable accommodations. And in this case, I can give you at least 3, if not more, examples of things that the department did to meet mother where she was at to accommodate her disabilities. The first thing that the department did was, as noted by my brother, mother could not, or stated that she could not tolerate treatment, a therapeutic treatment in a group setting, and this became an issue with the dual diagnosis. And yes, the department did make, and there is a finding, that the department made 2 referrals for dual diagnosis programs for mother. The first one was for a group setting, and you'll see in the findings that the second one was for an individual one-to-one setting. I would also point out, and this was dismissed or glossed over by my brother, however, the department did work with mother around her high point clinician. Because mother was in a therapeutic setting, that high point clinician was not initially approved as a dual diagnosis provider. The department reviewed her credentials and ultimately agreed that she was appropriately credentialed to provide dual diagnosis services and approved that as a dual diagnosis program for mother. So that, I think, is an example of a reasonable accommodation by the department. I would also like to point, Your Honors.
How about the color coding request? I mean, that seems, it really seems so straightforward, right? Couldn't a worker have just sat down with her with some colored pencils and helped her out?
Well, I would like to point out to Your Honors that the department did review the action plan with her orally every month at each monthly home visit, and the court did make a finding that mother was fully aware of what was being required of her by the department during the pendency of the care and protection. I would also like to point out to Your Honors that the parent aide that the department provided the mother sat down with the mother and made a color-coded guide or guidance for...
that was for visits, right?
For visits, yes. So, first of all, there was no prejudice to her not having color-coded action plan because she knew what was expected of her. And there is an example of her getting color-coded guidance toward parent-child visitation, and she did not use it. The testimony was that she did not use it, and that was testimony that the judge accepted in this case and credited. And I would just last point you to another example. Well, there were so many examples, but I'll make another example. I don't want to use up all my time, but the mother was having difficulty tolerating communicating with the department. She was having difficulties during visitation. She was becoming very dysregulated around visits, and she was dysregulated with the social worker. So the social worker in the department changed its normal practice. And in this case, the department allowed mother to do visits for a time at the Greater Lawrence Community Action Center. Those visits were supervised by a parent aide. In addition, the social worker, who, yes, indeed, did testify she was not aware of the disability practice or policy, altered her practice and communicated with mother through collaterals and through mother's supports because mother couldn't tolerate, due to her anxiety, direct communication with the social worker. So although she couldn't pass the pop quiz that happened during the stress of trial, in substance, her actions were accommodating mother's disabilities as they came up during case practice in this situation. So it is the department's position that the judge did not err. There was ample evidence in these unchallenged findings of fact. And I would reiterate, mother did not challenge a single one of these findings of fact. And there is ample evidence in these findings of fact that the department altered its case practice and worked with mother and met her where she was at so that there were reasonable efforts and reasonable accommodations. And the reason that it was unsuccessful was, and I will move on to my next point, because mother was resistant to services. She was resistant to making the changes that were necessary to allow her to successfully parent these children and to address the parental incapacities that have raised over the course of this case, both with the sister and with the two children that are the subject of this case. So I would like to direct your attention to the issues around marijuana. I think this is a perfect example of mother's resistance. Mother, and I think the record is replete with examples of mother's inability to regulate her behavior due to her mental illness. In addition, marijuana itself became an issue when mother had a safety plan with the department, and the removal was prompted by the fact that mother did not abide by that safety plan. She was in a caretaking role with the son, and she was sleeping and could not be woken when the department arrived. And so this prompted the department's removal, and also during that removal, mother became highly dysregulated and inappropriate. Her inappropriate behavior is documented well throughout the record. There are examples of her calling and referring to the daughter by vulgar language, right up until the care and protection trial, where she was yelling and screaming at the DCF attorney. There was an instance where she left the courtroom. There was another instance where she was having a panic attack under a sink in the bathroom. So there's a lot of documented instances of mother really struggling to control her behavior and keep herself regulated. And so one of the things that happened in this case is that the department repeatedly recommended that she get into care with a medication provider, that she discuss psychiatric medication with a provider. There were multiple referrals made for a medication provider, and mother continually insisted that she was addressing her emotional dysregulation with marijuana. Now, as I pointed out, the department had concerns about the marijuana consumption based on the incident surrounding the removal. But in addition to that, and also in addition to the fact that she was using $400 of her $402 cash benefits on the consumption of marijuana, purchase of marijuana, in addition to that, mother was relying on the marijuana to regulate her behavior, which clearly it was not regulating it. And ultimately, where we landed was that mother was at trial saying, "I'll deal with it myself." She was not going to get treatment for her mental health. So that resistance is the other reason why I think that mother's arguments regarding reasonable efforts fails. She has an obligation, as well as the department, and she did not fulfill that obligation. And for the reasons that, unless there are further questions, I would rely on my brief and ask you to affirm the lower court's decision.
Okay, thank you.
Thank you.
Still morning, Attorney Katz.
Morning. Yes, still morning. Good morning, Your Honors. Daniel Katz for the children. Just address one brief thing that Justice Hershfang brought up about what the department did in terms of visits. Department social worker testified that mother didn't come prepared to visits with diapers, with wipes, with healthy snacks, and the current parent aide at trial did make charts to prepare for visits, like writing, "Bring sippy cup," accompanied by an image of a bottle. So these charts had both instructions and also drawings that mother could associate with the tasks to do. That was provided by the department for the mother, and the mother never utilized those charts. As we know in these cases, the overriding arch is the best interest of the children, and mother's marijuana use was, or I should say misuse, was just one of the constellation of factors. And one of the important things throughout these cases is that a parent recognize any deficiencies they have. Hopefully they do get services. And even if they do attend services, if they're not able to benefit from those services and provide minimally acceptable care, then that hurts their chances. And of course, the judge can find that the evidence reaches clear and convincing evidence. And here we have a situation where mother admitted, or rather said, oh, the marijuana use is not a problem. And yet, there was a conviction for driving under the influence of marijuana, and mother admitted at trial that she thought her probation would continue because she hadn't participated in the program. Therefore, there's a connection between marijuana and the mother, again, making herself unavailable and furthering that unavailability to care for the children that she claims that she wants to care for.
Can I ask you a question? How would you address Attorney Penta's claim that what the department provided here was just routine services and not particularly tailored for his client?
Well, I think, Your Honor, I would hope you would agree that the specific instance of the charts, because in all the years that I've done this, I've never seen this type, doesn't mean it hasn't happened, of course, but this type of specificity where there's a problem. Okay, mother has a problem with preparing for visits. Department provides a helpful solution. Solution is provide these charts that are not just written instructions, but also provide pictures or photos or something, a visual image that can help the mother associate, oh, okay, I have to bring a sippy cup, boom, there's a photo of a bottle. So to me, that is what...
That's one. Do you have any others of the record that come to mind?
That's the main one that comes to mind in terms of a really specific service that is tailored to a woman who claimed herself that she had problems focusing at visits. So this was not only addressed to her inability to prepare for visits, but hoping that by using these charts, she would be able to engage more with the children, because her behavior was clearly dysregulated in terms of her inability to control herself. As I hope that you're...
That dual diagnosis thing, is that a unusual service, or?
It doesn't come up in cases that I've handled, both in representing children and parents. It's not something that comes up a lot that I've seen. But the key thing is that, and this sounds cliche, but this is a two-way street, right? There are services, and then the parent has to not only try to engage in the services, but there has to be some benefit from the services. And mother's behavior continuously throughout this trial, if we look at the order of protection that was issued against her, that involved threatening behavior to someone else, and not directly her children, but to children of the person who made the order. And there's testimony from mother in her inability, which is throughout this case, of having difficulty feeding the children. And constantly there's lots of, the record is replete with evidence of nutritionists or doctors trying to help mother and give her specific instructions about what and what not to feed, how often to feed the children. And yet there's a prime example and an image I'd like to leave you with. It's not a pleasant image, but in terms of advocating for my children, my clients, screaming at the daughter and saying, well, she can feed herself. And this was a very young person. Oh, my time is up. Okay, sorry.
No, thank you.
Thank you.
No, difficult case. We'll take it under advisement. So we are going to take our usual break that we take after 3 cases after this 4th case. We'll be back at 11:45 for the Reza case.
Rise.
Back right on time, 24P402, which is Reza versus Town of Merrimac, ZBA. Attorney Epstein.
Good morning, Your Honor. May it please the court. This case turns on principles of statutory bylaw interpretation, and the zoning enforcement officer had ruled without identifying the bylaw that there was nothing that would permit a landscaping business from being operated from 56 Birch Meadow. And the ZBA affirmed the zoning enforcement officer's ruling. It didn't get into the things that the trial court did. And then curiously, the trial court states that even if it is a similar construction trade, the town is entitled to summary judgment because of the 6 limitations that apply. However, if this had followed the appropriate due process, the building inspector, whose deposition makes clear he hadn't really thought it through as to what the violations might be in the 2018 encounter with an abutter, it would have stated that my client needed to get special permits in order to comply with the 6 limitations, some of which would have really very little to do with my client's business, because the employees that come to the site, they're there for a de minimis amount of time in the morning. They go off to work. They come back in the afternoon, and as comrades of the brothers might hang around for a few minutes to an hour or so while they enjoy the late afternoon, evening hour.
But isn't that an argument you're making as far as the special permit, that you would make for the special permit?
Yes, but that's my point, Your Honor.
But it doesn't bring your client's business within the requirements of the bylaw, does it?
If we submit, and it's crucial, that the first step in any analysis of the type of business that's being engaged in is it or is it not a similar construction trade. And we are convinced, based on case law, this being the first occupation of humanity is gardening, taking care of a garden, then taking care of themselves after they're evicted from the garden, that it is a construction trade, particularly because the bylaw is replete with requirements that landscapes be maintained, landscapes be constructed. So to leave this out when you have the phrase similar construction trade.
But where this is an exception for home occupations. Home occupations is not for businesses.
Well, it's called, the general category is home occupations.
And is this a home occupation?
It is a.
No, it goes out. They go out throughout the state, throughout the town, right?
No, it's only this particular business of home occupations that are trades, Your Honor, as opposed to professional, educated people or cosmeticians and whatnot. This is only permitted in a limited number of zones, including the zone that this business is being operated.
Your client could have. There's no problem with your client having his business office for this business with one other employee in his home. That'd be fine. That'd make it a home business.
That was permitted, but it's not just home businesses. Where's a carpenter supposed to put all the tools of his trade in his truck to go back and forth to business? What if it's Mr. Massing and Sons Carpenters, and your sons live with you, and you have 3 trucks?
But there's nothing here about trucks.
Pardon, Your Honor?
If I look at the 6 enumerated limitations for home occupations, nothing you've said about Massing and Sons Carpentry
Yes, Your Honor,
would
and
violate that. I'm still talking, right? So nothing that you've said about Massing and Sons Carpentry would run afoul of those 6 enumerated limitations.
But that is one of the complaints, is all of these trucks that are visible from abutters possibly, but not visible from the street, is that my client owns, and he and his brothers and one or two other employees drive away in trucks, while there's no limitation in the general bylaw or the zoning bylaw on how many registered vehicles may be parked on a property.
Isn't there an indication that there can only be, at most, a sign of certain proportions and not flashing to indicate the business? And are these not business-oriented trucks? They're not trucks that you would be driving for near you?
Yes, they're labeled trucks, but they're not visible from the street like a sign, Your Honor.
Right, but is that what it says, visible from the street?
It's implied that you'd have a sign visible from the street. In fact, I submit that it's required because you go from public nuisance, which would be a big sign on the side of the road, to a private nuisance, which is an abutter who, for whatever reason, dislikes what you're doing on your property. A 3.5+ acre parcel, by the way. We're not talking a crowded suburban area where houses are on even 40,000 square foot lots. We're talking houses that are on multiple acres of lottage next to a state forest, which is why I submit that you really need to look at the overhead image that appear in the record appendix at 17 to 34 and at the addendum at page 71 in RA 555, which was miscited in the memorandum. This is country. This is not a suburban enclave. This is country, almost to the New Hampshire border. There are farms around, including the back acreage of this parcel is a farm. And so without a determination, factually, legally, that it is a permitted type of business, because there's nothing, in our opinion, if you're going to try to read this bylaw rationally, reasonably, as to limit the disturbance caused by business. A law office with a lawyer and a secretary who has 4 or 5 clients visiting at a time and doesn't have adequate off-street parking can be causing a problem in the neighborhood because he's parking on the street. Same with a dentist, although lawyers is a special circumstance, but a dentist's office, a medical office, any of these other things listed will have customers coming to and leaving from the locus of the business. But this bylaw is written, and I submit it's written rather curiously, if it's trying to restrict businesses, because why, in each instance, do they, of the 4 types of businesses recognized, do they note that we're only providing examples, but there may be others that will fit in this, and that they're trying to be nice to those businesses by not requiring them to always go and get special permits. Here, we can't even go and get a special permit under this decision. It is submitted that you can only go get a special permit through the ZBA if you're a similar construction trade. If you're not, your route is a variance and a special permit, and as I read the bylaw, you don't qualify under that avenue of relief. You have to either qualify as a business accepted and allowed, similar construction trade in this instance, or you're out of luck. Because otherwise, the variances can be granted for all sorts of things. And you're only allowed variances for soil conditions, topography, and size. You're not allowed a variance for a use, at least according to the law as I understand it. I point out that there are so many constitutional issues involved in this case that required here at the appellate level to put in the record appendix and addendum and reference, and I probably left some out, that compel an understanding that the statute, if not read in compliance with the constitutional provisions would be either unconstitutional.
Can I ask, where did you raise the constitutional arguments in the trial court?
In the trial court, it was raised when I note in the memorandum that avoidance, effectively avoidance. I forget which case I cited. I may have cited more than one, Your Honor, but I believe I may not have cited Delaware and Hudson Co. 213 U.S., which I do in the appellate brief, but it is touched upon that you need to, zoning boards of appeals under Chapter 40A and the town do not have plenary power to control every use of property. It's just not there within the statute. And of course, the statute has to comply by definition with the constitutional requirements that their laws be wholesome and reasonable.
So doesn't your argument sort of make all zoning laws unconstitutional?
No, Your Honor, because here we have these vague expression, similar construction trade. What's it mean? Similar professional occupation. Well, what's it mean? And that's the other requirement, is that you got to avoid vagueness. And here, it's before the Zoning Board of Appeals, it was a hearing by surprise. And it's just not fair, fundamentally not fair to the REZZAs to say you absolutely can't have a business here, there's nothing to look at here, when he had been told about it in 2018, did nothing to bite the bylaw saying shall investigate.
Can you indicate that he went to the location and visually inspected it?
He went to the abutters location and investigated, but he didn't speak to anybody on the REZZA side of the fence, so-called. So how were they to know that a neighbor had complained about them? That's why it says shall. And it's familiar with my own town's bylaw in Georgetown, having served for a limited amount of time, but a full term on its zoning board of appeals. We don't use the word shall, we just use the statutory language. But Merrimac has chosen to use both shall, whether or not he gets a written complaint, and shall if he gets a written complaint. But they're totally surprised when they get this. They thought they'd been doing everything they could to accommodate the neighbors, but for a fire that had nothing to do with the business that occurred in May. And then they get buried in the record with photograph after photograph after photograph of activities happening on the agricultural land connected with the agricultural activity, which has nothing to do with the landscaping business. They get one abutter complaining to whoever will listen, because she sees in just about everybody in town, that acreage shouldn't even get the agricultural exemption. These were people who, during COVID, were so upset by a fire that they couldn't speak to their neighbors. They had to go and throw the kitchen sink at them without them knowing. Because a lot of what was developed in the record was not discovered until after the appeal. That's when we discovered that there had been 2 written complaints. One of which only complained about the fire, and the other one which said the business had grown. What can I say? That's not how I would treat my neighbor. It's not how neighbors should be treated. It's not how the law should be applied when it comes to zoning. This isn't a question of a building that was constructed above the elevation limit, which is clear and precise, or a proposal just going ahead and developing 40 acres of land without getting the special permits or other permits that you need from the Zoning Board of Appeals and the Planning Board. This is about what people do all the time. they conduct business from home. They might be a solo, they might be a family, and they go back and forth to work. What's leaving the property at 6:30 or so in the morning, and contrary to the conclusions that are made, 24/7 is not, they're not a 7-day-a-week project unless rain, like we've just had, is going to prevent you from going to cut some lawns. These are people who are good people, mean no harm to their neighbors, meant no harm to their neighbors, have been waiting for the arborvitae that they've planted on the property line to grow up so you can hardly see the abutter to the north. And it's curious because the only abutters who complained are the two to the north and the north.
Attorney Epstein, I think I'm going to have to hold you there.
I'm sorry, Your Honor.
Okay, no, thank you. I think we.
But as I conclude in my reply brief, based upon everything before this court, justice requires that this be a similar construction trade so that there's an avenue to go forward, not blocked by the requirements of a variance. Thank you.
Thank you.
Good afternoon, may it please the court. Matthew Preventure here for the Merrimac Zoning Board of Appeals. This court should affirm the judgment of the Superior Court, and it should do so principally for two reasons. There were no genuine disputes of material fact identified in the trial court, and the Merrimac Zoning Board of Appeals is clearly entitled to judgment as a matter of law. Frankly, the zoning bylaws at issue in this case are not novel, they are not complicated, they require very little in the way of construction or interpretation. They simply do not allow the use that the REZZAs want to conduct on their property in the zoning district in which the property is located. That is the beginning and the end of this case. All of the facts that are particularly relevant to the activities that are going on in this case were the subject of discovery. They were extensively addressed in the factual record before the trial court. I want to point out one thing where I specifically agree with what my brother said. I think the REZZAs are good people. I took their depositions, I got to know them a little bit. I like them. I think the testimony makes clear that when this business started in 2014, it didn't amount to much more than Mr. REZZA and a lawnmower in his pickup truck. But that hasn't remained the case. If it did, we might not be here, but instead it's grown substantially over the intervening period. It's now moved on to where there's almost 10 heavy-duty vehicles. There's multiple trailers being housed on the property. These are loaded starting at 6 o'clock in the morning during the work period. There are industrial-sized leaf-blowing machines that are ridden by workers. There are riding lawnmowers that are loaded onto the trailers. There's a device called a leaf sucker, which, to be perfectly honest with you, I'm not terribly familiar with, but it acts like a giant vacuum for leaves. All of these pieces of machinery are used in the ordinary activities of the business. They are stored on the property. They are activated and loaded onto the trailers. There's clearly and undisputably a significant amount of business activity that occurs at the property. Business uses in this zone are limited. This does not involve the agricultural use that occurs on a portion of the property. This only involves the landscaping business that's operated there. And I would submit to you that there's simply just no way to read the factual record, even in the most generous possible light, that would support any conclusion other than there's substantial commercial activity on the property. It's not allowed for in the zone. As you identified, Justice Massing, this looks very different from a home occupation. Those bylaws are common across the Commonwealth. They typically involve a single tradesman, usually assisted by a family member who works for the books or handles the accounting. There's an office in the room, and there's a workshop located somewhere within the primary dwelling. And the reason is obvious. Those are indistinguishable from normal residential uses. The uses that are being carried on here are demonstrably not. It looks like a contractor's yard, it acts as one, and that kind of use is not permitted in the zone.
Can I just, is there anything in the ZBA decision which affirms the cease and desist order that, as a matter of law, precludes an application for a special permit?
I've heard it referred to repeatedly, and to be perfectly honest with you, I don't think there's anything in the decision that bars them from bringing a special permit. I express no view as to whether they're likely to receive one, but if they wanted to make the application, they certainly could have. Similarly, if they wanted to seek some kind of zoning relief in the form of a variance, they could have made an application. What's equally undisputed, though, is that there's not only is there not a special permit for this activity, there's never even been an application for one, nor has there been a request for a variance or any other form of zoning relief. I think the unfortunate reality here for the Rezzas is, despite the fact that they're hardworking people, despite the fact that everyone can have respect for what they do in starting a business and employing their family and providing for them, it's not allowed on this property. They simply need to find another place to do it, one that's located in an appropriate zone, whether that's in the town of Merrimac or any other town. And I would submit to them that given the success of their business, that's not an unreasonable prospect. I think we would all hope that if we started our own occupation, it would grow to such a degree that we couldn't carry it on out of our house, whether because it's not permitted or because it's simply not feasible. So I would submit to you that the other issues that have been raised, I don't think any of these questions about constitutionality are really before this court. They weren't squarely raised at the briefing stage in the summary judgment hearing. They weren't really raised before the ZBA either. I think the reason that they're being put before you is because the factual record's extremely unfriendly to the appellant. I don't think they have a real basis to litigate any of those questions. And more importantly, even if they did, those are arguments to make to a town meeting about what kind of zoning bylaw should be passed. They're questions for a law school classroom about what the nature of zoning is and how it should be pursued by local communities. They're not arguments that are really submitted to this court and squarely addressed to the facts of this case. At this point, unless the court has any other questions, I will rest on my briefs.
No, seeing none.
Thank you.
Thank you both. The case is submitted. Next one is going to be, I'm going to pronounce it wrong. I'll just spell it, D'(ACCI) versus Mass DEP and Bristol Asphalt, which is 24P798. We're ready for you, Attorney Haler.
Well, good morning, Your Honor. It's, I think it's morning. My name is George Heiler. I'm here on behalf of 10 citizens who primarily reside at Kings Highway in Rochester, and this is the issues before the court today are whether the trial court erred in determining that the appellants waived the issue of odor at the administrative level, and then 2, whether the trial court erred in determining that air permit was supported by substantial evidence.
Could I, before you get started on this, and I don't want to use up all of your time, but I am interested to hear your thoughts on the argument that you don't actually have 10 citizens. At this point, you have 7 citizens, and what we do with that.
Well, Your Honor, I thought that issue was addressed in that it was established that we had 10 citizens at the filing of this action, and therefore we complied with that requirement.
So my question out of that, I see your point about that, but what if you had a situation in which you had 10 people who are still alive and available, and 3 of them didn't want to go forward on the appeal? Would you be able to pursue this appeal without those 10 people?
I don't believe so, Your Honor, but I don't think we have that situation.
And so you don't, so the absence of the 3 people just gives you a pass on the 10 citizen requirement is your point of view?
Yes, Your Honor. I believe that the reason why we don't have 10 is one's been deceased and one's passed on during this process.
And one is just MIA?
exact, can't be found. Again, these are residents, this is a location where there's a proposed asphalt hot batching asphalt plant that's literally right in the backyard of these residents, which is called Old County Road, and some of these people have been there for generations. It's the original access to Cape Cod before all the other highways, but that's another discussion. What I'd like to do is just direct the court to the emissions issue that both the second ruling at the department and the trial court erred in deciding that that odor, because it wasn't specifically mentioned within the public comment period that begins this process. So you have a public comment period on a pre-construction air permit approved by the local regional office. And there's a 30-day public comment period. That comment period, my clients complied with within the time allotted. And they did so with the use of an expert witness, a Suzanne Pisano, who has spent 30 years in this business reviewing the documents that were submitted to the department. She came down with conclusions based on emissions. The term emissions is used, and that there was a need for additional air quality modeling, which is this calculations on once this operation becomes active, you will have emissions, air pollutants, migrating onto these residential homes and their properties.
Go ahead. As a result of those comments, didn't the, I'm not sure which entity it was, I get confused, but didn't some entity take action and actually ask Bristol Asphalt to change where some of the monitors were and to do some additional studies?
Yes, there was some work done that was to respond to the DEP engineers. What our engineer based the emissions requirements for air modeling was her review of documents at the time. What we're looking for is the court to grant relief to bring this back to an evidentiary hearing at the department to discuss these exact issues.
Okay, but why? I mean, I'm looking at Record Appendix Volume 2, page 58, which you'll tell me if I'm wrong, I hope, has a set of bullet points that I understand to be the specific comments, the specific challenges that your clients made during the open comment period. Do I have that part right?
That's correct.
Okay. So I read through these. First of all, is there any contention that either Bristol Asphalt or Mass DEP, depending on whose responsibility it was, failed to address these bullet points?
Yes, we believe that there's some additional work. They rely on best available control technology. We believe you can't really make those conclusions until you do this additional air modeling.
Well, by additional air modeling, are you talking about now something related to odor?
Again, this is where we get into the emissions definition versus...
No, I don't want to get into the definition because I think it's helpful. I mean, eventually, obviously, you will. But I think it's helpful to start with these actual bullet points because this is what... this is how the open comment period works, right? There's yes. Comments made so that the applicant and DEP can know what the issues are, and then there's either action or inaction in response to them. So when I'm looking at what was submitted, the air model should have placed sensitive receptors at the residential homes. Was that done?
No, I don't believe, no, there's not. There was no air modeling. That was one of the requests of our expert to do some additional monitoring within the property lines and some additional sampling of different parameters.
And is there anything either in this set of bullet points or in the related items that were submitted along with it that says by sensitive receptors, I'm talking about odor receptors? Is there even such a thing?
Yes, there is. Since odor has subcomponents, for example, hydrogen sulfide, PAHs. There are sampling techniques, and this is what our expert recommended to the department.
Well, I saw she recommended it in September of some year that I wrote down but cannot currently respond, and my handwriting is terrible. Oh, no, I'm sorry, September, a report from January 26, 2022. But was there anything contemporaneous with these comments that talked about odor or receptors to measure odor or receptors to measure particular gases that are known to produce odor?
Yes, it was called emissions. The emissions request was to do the array of subcategories of what emissions. Odor is just one of those. Odor, dust, fly ash, PAH is high. What our experts said was emissions for that particular facility needed to be tested further. What we're saying is that it's very difficult to figure out what type of control equipment that you need to put on a facility that is literally in people's backyards to prevent odors, one, but there's other constituents within that definition of emissions that needs to be taken into consideration. And that's what we want to
But you're appealing only on the odors. My understanding of your appeal is that you're talking about odors, not
We're
the
talking
other
about, but again, I was just kind of clarifying the definition of emissions that include, odor's just one of those, but we were focused on the odor issue, but there are other
That's the problem, though.
parameters.
How do we know that you're focused on the odor issue? So one of the other emissions, actually, it's not an emission, it's a contaminant. You've got to go from emission to contaminant to the list of, and two of them are radioactive material and radiation. I assume there'll be a completely different receptor to measure radioactive material and radiation as opposed to odor.
Yes.
And so are you saying if you had come to after this and asked, actually, we want you to do more research on radioactive material, and we said contaminant, so you should have known that?
No, Your Honor, what we're saying is the actual type of plant that this involves has specific type of constituents that need to be tested for. And we believe that they weren't tested specifically, which included odor. But odor was our focus based on the preliminary feedback from the residents. That's what their concerns were.
Right.
But the original report, I think the answer to this is yes, the original report did not specifically address odors, correct?
That's correct. It mentioned emissions.
Okay. And
which is, odors defined in emissions.
I understand your point on that. But the report itself discussed specific emissions according to specific criteria, the 2 air quality testing standards, I think. Your comments don't suggest that those testing parameters were too narrow, as far as I read them, or am I misreading them?
No, Your Honor,
And so for that reason, how would a reasonable reader of these comments that you make understand, given what the report itself dealt with and what the report itself did not explicitly deal with, that you were talking particularly about odors? I understand that they're included within emissions, but where does that notice come from?
Your Honor, there's the difficulty in this whole process of achieving this type of permit. The department basically approves these pre-construction permits, and at the end of the day, they go, once you're done, we'll find out what the problems are. That's what our concern was, is that you're looking into the future. So that, and we believe that the department should have created, and this goes to my second argument, that they're in violation of their own regulations, their air pollution control regulations, and that they've never established thresholds, they've never established criteria for odor and some of these other constituents that are defined in emissions. And if you look at some of within my brief, we mentioned that odor and dust are mentioned, but the department has had decades to do it. I will tell you this is a subtle irony. I'm in front of the court since when I worked at the department in this very department at air quality while I was doing the night school, law school, back in the mid 80s, and this issue was presented. The department has had ample time to create this criteria, so you don't have these issues where where you have the department just saying, okay, go build it, and we'll figure it out after that. And that's basically, we'll rely on the applicant's testing, and we will rely on some of the data and what's customary practices. And I only want to bring the court's attention to the 2024 case at the appellate level that upheld an injunction against it would be Keating versus Acushnet, which is an incredibly similar parallel permitting process. And in the same region, I might add, approved this, and knowing full well that a lot of these parameters have no criteria. And again, I'm here because we believe that emissions established, by saying emissions, our expert was including odor. But the court's correct when they state that, what's the benchmark? There isn't one. And that's the problem we have. And there you're going to have, I can predict the future in this case, is that the department needs to comply with their own, and promulgate their own, it's the Department of Environmental Quality. They need to promulgate some regulations that address these issues because they're reoccurring. We're not saying that asphalt batching plants are bad and can't be built, but we should be doing some more in-depth studies and criteria to define that.
But isn't the current, I'm not saying this is a good or the ideal situation, but isn't the current framework that because there is no testing or advanced mechanism for measuring odors, that Bristol Asphalt in this case runs the risk that they're going to spend all of this time and money litigating and then more time and money building and open their plant, and then it'll be in a Acushnet situation where they get sued and maybe they can't operate it.
I'm in agreement with you. Your Honor, this permitting process and this approach by the department serves not only as a disservice to the residents, but also the applicants who again, large capital is an issue. Again, I'm being very pragmatic here that my second argument is the departments in violation of their own regulations when they have not established some type of criteria, because everything becomes arbitrary and capricious. You know, the substantial evidence is not there for a reasonable mind to adequately make this condition that a permit would be prudent without additional information and criteria to establish it.
I'm trying to find your complaint, and I can't find it in this huge record right now, but I'm curious, how is this question about the regulations not being appropriate? It's sort of a 30A argument, right?
Yes, it is.
I mean, do you have a separate 30A appeal as opposed to this one about the standing?
No, Your Honor, I'm just relying on 310 CMR 7.51, which is the U-hearing relative, and what the process is. This is actually a first for me. I've never seen a written comments within the prescribed time be dismissed on a motion to dismiss, which I might add the original decision, which is, I believe it's volume 3, document 32 of the administrative law judge, states was against this motion to dismiss and found in favor of the plaintiffs that odor was part of emissions and we should have an evidentiary. For some reason, there was a show cause order that was.
I know. I think at that time she sort of took it in the light most favorable, and then on with more evidence decided that
yes,
she had that.
That's fair. But again, nonetheless, there was a decision at the department that we're in front of the court on asking for that relief, to have that evidentiary, to define those thresholds, to define how much odor or other parameters that come in through the emissions.
So let me ask my question a different way. If we agree with the DEP's determination that you hadn't raised the odor issue appropriately in the comment hearing, do we even reach the regulation question?
I think that's a problem, that the regulations should be written, but I also think that through this administrative process, it's been my experience through a few decades that these situations are ironed out between professionals. And what's adequate and what isn't. And I defer to that, even though I try to play one on TV. as a scientist.
All right. Thank you.
Thank you.
Hear from, so we're the appellees are dividing their time. I think we're hearing from Bristol Asphalt first.
Thank you.
Good afternoon, Your Honors. My name is Brian Hurley, and I represent Bristol Asphalt. I had a whole argument prepared, but in light of what I've just heard, I'm going to change it just a bit. The reality in this case is that 10 citizens brought an action and initiated a process. And the reality is most, if not all of those 10 citizens don't know anything about this case. The reality is that my brother represents the Tedesca family that owns a bituminous plant in the very same neighborhood. So the concerns that we hear about the smell and the odor and the problems associated with a bituminous facility are really a little bit hollow. I will say this, so...
Is that point really relevant to any issue in front of us?
Probably not, Your Honor, but it troubles me to hear it sound as if we're here to save the day.
It's asphalt plant in your backyard is gonna stink, right? I mean, it's kind of a reasonably foreseeable thing, right?
It has a smell, there's no question about that. But understand that there's been an asphalt plant in this neighborhood since the 1990s. And it's his client that ran that asphalt plant. But let me step back from that. That's just me being my fit of pique with respect to the argument that was made. The reality is that we went through an exhaustive situation with OADR. They asked for additional testing from us. They asked for all sorts of information. They wanted us to do dispersal modeling. At the end of the day, they didn't require anything about odor because the regulations don't address it. And maybe the regulations should be amended to include odor. Maybe that's a great idea, but the reality is it wasn't in the regulations at the time we applied. So we go through this exhaustive situation with OADR. They look at all the issues that are associated with this development. They issue a permit and have many conditions to that permit that will ensure that the very kinds of problems that are being discussed today and envisioned will be addressed. So it's not as if the state, through its agencies, was ignoring the problems here. They were dealing with the regulations as they are written today. They imposed the conditions they felt comfortable with imposing under the existing regulations, and they will look forward to monitoring that when we finally finish doing this facility. So I can't see how OADR's decision was faulty or wrong or improper in any way. They dealt with existing conditions, and indeed they required, as part of the process, that we do additional air modeling. So I think the state did its job. I think it applied the regulations fairly. It conditioned the approval. It'll continue to monitor what we do once the facility is built. And so I think all of those issues, frankly, were taken care of. And there's just simply no reason to overturn that ADR decision. That was the decision of the Superior Court judge. I thought it was a thoughtful decision. He went through all the elements and concluded that OADR's decision should not be overturned. And I will ask this court to do the same, not to overturn the well-considered decision and opinion of the people who are charged with the responsibility of reviewing these kinds of facilities. I wanted to address briefly the standing issue, Judge Masson, that you mentioned at the beginning. And quite frankly, I don't know what to make of the standing issue. You have a 10 taxpayer suit initially. Obviously, the reason to have 10 taxpayer suits, I don't know how they arrived at the number 10, but that was the number the legislature arrived at. And the purpose was to allow...
It wasn't the legislature, right? This is a DEP regulation.
That's right. It's a DP.
So you have to have 10 people to ask for an adjudicatory hearing.
That's correct.
Do you have any case law that says that requirement funnels into the right to appeal to Superior Court, let alone to appeal to this court?
Well, there's no case law either way on that. I mean, I'm not aware of any situation where the number has changed. But my point is that allows a substitute for standing. So the people who want to complain about a particular kind of use in their neighborhood, they can do that, and they don't have to show individual standing as long as they meet the criteria of 10 persons. It's an arbitrary number. I don't know where the legislature comes up with that, but that's the number that they chose. When you go to 7, I don't think you can rely on that statute anymore. And I think you have to show individual standing on the part of each of the people that were involved. And if you agree with that premise, then they fail to do that. There's no evidence in the record to show that any one of these people who signed on to this effort have any kind of special injury that would rise to a level of giving them standing to bring individual lawsuits. I guess all I'm saying to you is I don't think we can ignore the fact that 10 taxpayers became 7. And I don't think we can assume that jurisdiction continued, notwithstanding the loss of those people. I think that each and every one of the 7 would be required to show that they had standing in the case. And unless and until they do that, I think the case should be dismissed on that basis. And I realize that this is a new issue. I have no cases to issue in support of it, but just from a common sense standpoint.
Makes it an uphill battle, doesn't it?
Just from a common sense standpoint, it seems to me that people shouldn't get a pass by starting out with 10, going to 7. I mean, under that theory, you could go to 1. I mean, what difference would it make what the number is? I don't think that should be a basis for standing in this case. So I think that the Superior Court judge got it right. I think his review of the decision was appropriate. I think that we should move forward with this competing plant. I think that DEP will continue to monitor and evaluate this project to ensure that the people in the neighborhood are not bothered any more than they are now by the existing asphalt plants. And I think the decision of the judge should be affirmed. And I think that's probably all I have at this point. I think everything else is covered in the brief.
Okay, here, no more questions. We'll hear from DEP, I guess.
Great, thank you, Your Honor.
I can confidently say good afternoon, Your Honors. I'm Samuel Fergang on behalf of Mass DEP. There isn't much I think I need to say given what I've been hearing from the court and what has already been argued. I'd like to just point out a couple of things that may be of assistance in reaching a decision. One is I would like to refer the court to the direct written testimony of Thomas Cushing, who was the Air Quality Section Chief at the time that the regulation was promulgated. It begins in volume 4 at page 151. And he goes into some detail about the reasons why there is no requirement or regulation and goes on to explain the efforts that were taken instead to take into account the potential problems of odor in a plant such as this. And those efforts were outlined in great detail in the conditions that the department imposed on the construction of the plant, and they appear in volume 2 of the appendix, beginning at around page 84. And there is a very detailed list of things that the company had to do to ameliorate any risk of any kind of emission, including odor. And they included, as we say in the brief, the use of a substance called EcoSorb, which is specifically designed to absorb odor, to monitor the emissions and vapors from the silos and the reservoirs of asphalt on the plant, having continual monitoring, and most importantly, and this is actually included in the conditions itself, but also is true as a matter of law, that the department has the ability to take additional measures, including shutting down the plant, if odors reach a level that become an active nuisance. So that's on the other side of this issue, which is what do we do with odors if we aren't testing it in the outset? So there's a reason why it isn't tested at the outset, and that's explained in Mr. Cushing's testimony. And there's a reason why there's not a regulation about that, and that's why the plaintiff's efforts would be invalid, because there's no basis for the department to require any testing of odors prior to construction. And here I want to get to the other part of this case, which is really the formative issue, which is the failure to notify the department that odor was a matter of concern to them. And today I heard my opponent say, and I'm quoting here, odor was our focus. And if odor was indeed the focus of the plaintiffs, it would have behooved them to let the department know about it. But they didn't. They were concerned about the air dispersal modeling. The department paid attention to that and did something about it. It would be impossible and unfair to expect the department to do something about a concern that was not expressed. And that's the whole purpose of the regulation at issue here. The whole purpose was to give the department and the applicant an opportunity to address any concerns before the adjudicative hearing, so that everything could be done in a streamlined fashion and not avoid piecemeal litigation of the kind that we would risk experiencing if the plaintiff's position were to succeed. What happened here was what was supposed to happen under this regulatory regimen. You give the public an opportunity to provide comments that are specific, that can be addressed. The department then looks at those comments, addresses them where necessary and where appropriate, and then they move forward to the adjudicatory phase. If there is a concern, one and done, and if there's an objection, we come here, and then the plan goes forward. That's the model, that's what happened here, and that's what should continue to happen.
Do you have a position on this 10 taxpayer situation? I saw you studiously avoided it in your brief, and now I have you, so.
I would prefer to continue to judiciously avoid commenting on that. It is an interesting issue. I certainly agree that my colleague here has a colorable argument, but at this point, the department doesn't want to take an issue on that.
Very diplomatic.
Thank you, Your Honor.
I'm going to ask you one question. You directed our attention to Mr. Cushing's letter, and he refers to the testimony of Ms. Pisano, and where her testimony, paragraph 10, actually talks about odors. Where is that testimony? Where is that testimony that he's referring to? When did she give that testimony?
I don't recall, Your Honor. I can't imagine it being prior to the submission of comments. Or I believe it must have been subsequent to that, because if there was any testimony about odor, it would have, prior to the adjudicatory phase, it would have been a part of this appeal and would have been addressed in the comments by the department.
I think it's Record Appendix Volume 3, page 111, which is her report from January 26, 2022.
Right, which would be subsequent to the public comment phase.
All right, thank you.
Thank you.
Thank you, Justice Hershfang. Okay, thank you. We'll take the case, we'll submit, the case will be submitted. We'll take it under advisement. Thank you for your arguments. Thank you for your briefing. And last but not least, a holdover from last week. Estate of Gravel. And I hope you're all better now. Okay. Well, go ahead.
May it please the court, Stephen Levake for the appellant. We're here today on an appeal of a grant of summary judgment in favor of the appellee upon the appellee's motion for summary judgment. The issue presented before the court was an interpretation of a trust and whether or not that trust should be classified as a nominee trust or a revocable trust. It's the contention of the appellant that the trust itself is not a nominee trust and does not comport with the elements of a nominee trust as enunciated in Guilfoyle versus Secretary of Executive Office of Health and Human Resources, 486 Mass 788. That case specifically enunciated several elements in which a trust could be interpreted to be a nominee trust. Two of the elements are lacking in our trust, the trust that's in dispute. It's our position that the judge wrongfully interpreted the trust to be a nominee trust, despite the lack of those particular provisions, and further incorporated some facts outside the four corners of the trust. In Guilfoyle, two of the elements that the trust enunciated was I'm going to go number 3 and number 5. Number 3 was that the trustees lack power to deal with trust property except as directed by the beneficiaries. And number 5 was that a single beneficiary could terminate a trust at any time because upon creation of a nominee trust, their interests vest at that time. Now, it's our contention that the trustee in this particular situation retained significant fiduciary authority to administer the trust without the direct input from the beneficiaries. And further,
well, subject to the approval of the beneficiaries.
Subject to the approval of the beneficiaries, Your Honor, as stated in paragraph 2 of the trust. However, further down in paragraph 2 of the trust specifically says that the trustee can act upon certain powers without seeking court approval or consent of the beneficiaries. And those powers include to manage real estate, lease property, borrow, and specifically, and of most interest, this was an issue I think the judge perhaps overlooked. And what I'd like to point out, in item J of these powers, item J enunciates a different standard, says that generally in all matters, to control and dispose of the property, including all instruments thereof, shall be shown to be in his or her judgment for the best interests of the beneficiaries. In addition...
But can I pause you there for a minute?
Yes.
Obviously, that's very broad. I would imagine that one of the things that's encompassed within that is selling the property, right? But there's still that final clause shown to be in his or her judgment for the best interests of the beneficiaries. And the beneficiaries were identified at the time this trust document was made. And I think we can all probably agree with hindsight that this could have been better drafted to do whatever it was intended to do. But it doesn't say in J that the beneficiaries can be changed.
Correct, Your Honor. But the question becomes, if it's a nominee trust, the beneficial interest vested upon her signing this document in 2017. And I think we have to look at the second component of what was entitled Schedule of Beneficiaries. If we look to the Schedule of Beneficiaries, we'll see two elements in the Schedule of Beneficiaries. The first being that Mary Jane retained the power to essentially spend down the entire corpus of the trust prior to the beneficiaries attaining the age of 25, which in and of itself imposes the second condition that upon attaining the age of 25, they were to get the balance of the trust absolutely. There is an inherent conflict here. This cannot be juxtaposed into a nominee trust if Mary Jane retained the power to actually spend down, and by the way, spend down perhaps for the benefit of one beneficiary solely, and then in addition, hold the property until the children attain the age of 25. That tells me that what she created, or what she intended to create, was a contingent remainder interest. She gave them an interest as a beneficiary in the trust. She did not give them an interest in the corpus of the trust. She reserved the power to spend down that corpus and she conditioned the children receiving the corpus of the trust, or what would be left, until they attained the age of 25. And I would also like to note, in the schedule of beneficiaries being a separate document signed by Mary Jane, there is no condition to seek approval of the beneficiaries. That is not a condition in the schedule of beneficiaries.
But it doesn't have to be. I mean, it's in the trust, right? So if we assume that the trust is not internally inconsistent, it would be adequate to say in the trust, you need the approval, and then to say in the schedule, here are the people.
Traditionally, that's what would happen. You'd say, here are the people. However, in this schedule of beneficiaries, we deviated from naming the beneficiaries to granting Mary Jane additional powers. Those powers are fiduciary powers. So she reserved powers in the schedule of beneficiaries not to act at the direction of the beneficiaries or with the approval of the beneficiaries, which are two different issues. But in Guilfoyle, it says the trustee is merely a vessel which is to act at the direction of the beneficiaries. This language contained in the schedule of beneficiaries is wholly inconsistent with that. If she has the authority to spend money on behalf of a beneficiary without their approval or without their direction, and further, that their interests didn't vest immediately in 2017 if they had to wait until they were 25. I would go further to say that it implies a survivorship requirement, that what happens if they don't make it to 25? So if we take these inconsistencies in this trust and we say to ourselves,
so how does, for example, changing the beneficiaries, is it consistent with her expending a whole or part of it in, for the benefit of the beneficiaries, named herein?
excellent question. And so if the trust is not a nominee trust, theoretically it is not an irrevocable trust, which means it's a revocable trust. If it's a revocable trust, under 602, Section 203E, 602, she has the right to amend a trust by any clear and convincing evidence of manifest intent, which she did. She signed a document manifesting her intent.
Well, actually, I mean, isn't it the, I mean, I know there's identity between the trustee and the settler, but it's the settler that has the ability to do that, not the trustee.
Correct, but the statute doesn't state that it has to be any formality to amend the trust. The statute just says any evidence manifesting intent. So if she's wearing two hats and she signed it as trustee, or perhaps she would have signed it as grantor, but she didn't write that, or maybe she just signed it individually without indicating if she was signing as grantor or trustee, she still manifested intent to amend the trust. So if we're not a nominee trust, we fall squarely within 602 that says the trust is revocable. If the trust is revocable, she has the ability to amend the trust without seeking the consent of the beneficiaries, which raises another question that we had before the court, and the issue is a legal impossibility. Now, I raised the issue before the court on the minor beneficiaries being able to have the capacity to consent to major decisions for the trustee. So if the trustee wanted to sell property, could the minor beneficiaries consent to the sale of property when they lack capacity? And that's not provided for in the trust. And I think where the court may have veered off, the lower court veered off, was to speculate and say that the legal guardian could have done something, or the legal guardian could have been appointed a conservator. Well, if we're saying that the legal guardian had to be appointed the conservator, then we're saying that the children didn't have the capacity or didn't have the ability to give approval, and we're faced with a legal impossibility written into this trust. And we have to discern the intent of the testator. Why didn't she provide a mechanism if the children were minors to be able to do that? Now, we can jump to the prospect where the lower court did and said, well, the legal guardian can give consent. And in fact, in the lower court decision, the judge referenced that the recording of the deed evidenced a passive acceptance of Shane of the creation of the trust. And nowhere is that stated. And in fact, he wouldn't have had to passively accept anything because he was only a successor beneficiary, he was only a successor trustee and not a beneficiary. So these issues that were raised at the lower court, I understand the court was trying to pull out and discern the elements of a nominee trust, but I think we were putting a square peg in a round hole. Can I go? Okay. I didn't know if there was a question. I apologize. So it's our contention that when read collectively, not only paragraph 2 of the trust with the reserved fiduciary powers and the schedule of beneficiaries with the reserved fiduciary powers, that the trustee was allowed to act beyond the scope of what a nominee trust is, which requires direct approval of the trustee's actions or the direction to the trustee. In other words, a trustee cannot act unless given a direction from a beneficiary. And also, I would like to point out that in Guilfoyle, the court did identify the issue that a single beneficiary can terminate the trust at any time once a nominee trust is created. However, interestingly, this trust was created with the provision that it had to be a majority of the beneficiaries. It's our contention, why did Mary Jane put that in the trust? Because she did not intend for their interest to vest until she was ready to give them the money at 25. And therefore, each individual beneficiary did not have the power. Because they didn't have the power, their interest was not vested. These are material components, and in Guilfoyle, what it was addressing was, it was addressing the issue of a person applying for Medicaid. And in applying for Medicaid, whether or not the trust was going to be treated as a countable resource. And that's why the court went through and enunciated the 5 elements of what a nominee trust is in order to discern that that trust was in fact a nominee trust. And the distinctions on the interpretation of this trust versus what was in Guilfoyle the court said that the beneficiary has the unfettered power to terminate the trust. That's not here. That the interests were vested upon the creation of the trust, and we contend the schedule of beneficiaries does not say that. The schedule of beneficiaries says that they get their interest, and interestingly enough, at the very end of the schedule of beneficiaries, upon attaining the age of 25, absolutely. That's at the end of the schedule of beneficiaries. Now, also, we would contend that the trustee had fiduciary powers, and so as a result, this trust does not fit within the context of what would be deemed a nominee trust. In fact, I would suspect that if Medicaid were to challenge this trust, it would be a countable resource because of the powers she retained. And therefore, it's not a nominee trust, it's a revocable trust under Section 203E, 602. It's a revocable trust, and as a result, she exercised her manifest intent to amend, and because of her amendment, the amendment should stand, and we would say that the court erred in granting summary judgment by, number one, erred in law, by interpreting the trust, and number two, incorporating some facts that were not part of the trust instrument, which included the possibility of Shane becoming a conservator for the benefit of his children, and also included the assumption that Shane passively accepted on behalf of his children the deed conveyances. And for those reasons, we'd ask that the judge's decision be overturned.
And what? What happens if the judge's decision is overturned?
So if the judge's decision is overturned, my client would have the right to present evidence at a hearing or trial as to what this testator's intent was. That her intent was not to relinquish full control.
Okay, so there would be, it'd have to be more, you say the parole evidence or whatever to understand the terms of the trust?
Yes, Your Honor.
Okay. All right. Okay, thank you. We'll hear
Thank you.
from the, your brother, or your client's brother. Your client's brother's attorney.
Your Honor, Your Honors, first of all, thank you for getting us rescheduled so quickly, number one. Number two, if it pleases the court, my name is Kevin Diamond. I represent Shane Gravel and the 3 minor beneficiaries of the Everest Realty Trust. I'm going to start out 200 years ago, Your Honor. We have had 200 years of common law for the wills, the area of wills, estates, and trusts. And it was only about in the last 12 to 15 years, after 10 years of working on it, that we created the Uniform Probate Code. And the Uniform Probate Code was the first time that we've codified and defined many of the terms that are used in the area of wills, estates, and trusts. And subsequent to that, we created the Uniform Trust Code. And those have provided guidance for us and many of the definitions that we'll talk about today. First of all, Your Honor, to state that the judge wrote a very clear decision, and he called this trust, whether it be a nominee trust or whether it be a revocable trust, that it didn't meet the elements as required and therefore was void ab initio. And my brother has the burden of showing that that is a clear error. What I'd like to do is bring you back to the original intent of Mary Jane Gravel. Mary Jane Gravel met with her well-known estate planning counsel to create a trust to take the Gravel property that had been in the family for 4 generations and to transfer that property to her only 3 grandchildren. Mary Jane Gravel, as my brother says in his brief, and his mother had a contentious relationship. And as part of that contentious relationship, she disinherited him. But she wanted to protect the children, the grandchildren. And the way that she did that was by allowing the children to have the power to amend and the children to have the power to revoke. And what she didn't do in her trust was that she willingly gave up the power to amend, the power to revoke, the power to terminate, or any ability to get the property back. And how do we know this? We have 4 documents that substantiate her testamentary intent. We have the trust that she worked on with counsel and she signed and executed. We then have the schedule of beneficiaries. And the schedule of beneficiaries say that the property will go to her 3 grandchildren, but it's going to be for the guardians. Will be there to protect the children. And the guardians most often are the parents who are here today. She then signed 2 deeds and 2 certificates of title. Those deeds and those certificates of title were then recorded at the Worcester Registry of Deeds. At that moment, this was a completed gift to the trust, and Mary Jane Gravel had no way, no method under the documents to take the property back. My brother in his pleadings had argued subsequent intent. Today, he didn't argue that. There is no subsequent intent because we're bound by the 4 corners of the trust, the schedule of beneficiaries, as well as the 2 deeds and the 2 trustee certificates.
Before we get there, you actually started with intent, and of the 2017 documents, and you said that happened.
At the time that she executed the trust, because Shane was not named as a beneficiary of the trust, he was named as the trustee.
Okay.
So his mother, knowing that Shane was a contractor, and this is his 3 children, and they lived on the property, would take care of the property. But because of their contention, as my brother points out in his pleadings, but not today, that she specifically disinherited it by leaving it to the grandchildren because it had been in the Gravel family for 4 generations.
So it's why would you create a nominee trust, which is usually run by the beneficiaries, to minors?
Your Honor, what I see this as is an irrevocable inter vivos trust. It has elements of both a revocable trust and it has elements of a nominee trust. So in the nominee trust, in the first half, we see that the property was transferred, and therefore it was a completed gift under that standard. But the trust, as Judge Hershfang had said, lacks a little clarity in there, but the trust then goes on and gives items that must be powers and there were powers that Mary Jane Gravel did not retain. The ability to amend, the ability to revoke, the ability to terminate, or any methodology to get the property back. So it was a completed gift. Now, to the extent it's an irrevocable trust, was that a revocable trust requires that the grantor unilaterally have the power to amend or revoke. Here, Mary Jane Gravel protected the grandchildren from not only herself, but from Shane or any subsequent trustee by saying that the children had to, 100% had to vote in order to approve a new trustee, which wasn't done, and 51% to terminate the trust. And the idea of terminating the trust, it was well written in that you have 3 beneficiaries. And the 3 beneficiaries, if 2 agreed that they terminate and 1 didn't, you had to have a majority here in order to terminate. So that was well architected. And if the trust was terminated, it went to the 3 beneficiaries as tenants in common. So the design of the original trust was to protect their interest and, more importantly, protect them from any trustee, because they had the authority to amend, they had the authority to revoke, they had the authority to terminate, not the grantor and not the trustee. Your Honor, my brother's argument fails on his own pleadings. If we look at page 21, he gives us the definition that he found in the Mass Code of Regulations on what is a revocable trust. And a revocable trust, he says, is that the grantor retains the authority to revoke the trust. Here, by the terms of the trust, Mary Jane Gravel did not have the authority to amend, revoke, or terminate the trust. She had no authority over the trust, and therefore, it was irrevocable for her. He further on, in page 21, he defines an irrevocable trust, and this trust meets that definition of an irrevocable trust. Next, I would take exception to the Schedule of Beneficiaries and how he articulates it. The Schedule of Beneficiaries has to be read together with the trust. And the Schedule of Beneficiaries states that the 3 children are named, and then it names the guardian. And Your Honor, when he talks about a legal impossibility, I'm appalled, because when you have a trust is created for minors, incompetence, unknown, and so it's society's most vulnerable. The idea of a trust, to say it's a legal impossibility where they name the guardian. If we go to the MUTC, we'll see the definition of what is a guardian. Not only that, Your Honor, the court went further, that the guardian for many years was someone who took care of not only a person, but of their finances. And then the court broke out at the time they created the MUPC, they created a conservator. And this was a special category where a conservator was an individual who took care of just the financial assets, that there were many people that didn't need to have their person taken care of, or they may need both, but the court separated them. So the court has always recognized guardians, guardian items. There's a methodology within the Mass law that if you wanted to challenge a trust for mistake, you could. But my brother didn't do that. What his client did, a non-lawyer, created an amendment to a trust on his own without legal counsel and without complying with the terms of the trust. In his argument, he also references a possible conflict of interest between naming Shane as a trustee and Shane as a guardian as the parent. However, I see a greater conflict where Jason, acting as his own attorney, does a trust amendment that names him as not only as the trustee, but the sole beneficiary of the trust. So the parity isn't lost on me that the conflict of interest lies with the instrument. But most importantly, what they had to do within that instrument is comply with the terms. And the law in the cases cited said, if there's a methodology that's given, then that methodology must be followed. So that my brother is misquoting the law where he states that under 602C2, that we're looking to the intent. If we go to 602C1, it says follow the methodology that's given in the trust. And that methodology was very simple. you needed 100% of the beneficiaries or 51% of the beneficiaries, depending whether you were amending or terminating. And if we go back to the schedule of beneficiaries, we named the beneficiaries, they were minors, there were guardians, and the laws, as we look at the MUPC, defines what is an incapacitated person. It's a minor. It defines what is a conservator, what is a guardian, who is a protected person. It's a minor. These children would be minors and they would be protected under the MUPC. And in fact, this law is so strict on the idea of a guardianship that under Mass General Laws, Chapter 190, in Section 5-301, delegation, one parent cannot delegate the authority if the minor has another parent. So in this instance, this trust was written, and it said if Shane was doing something that the children didn't like, their mother could step in and have legal standing to represent the children against the successor trustee. So there was clearly a methodology, and the idea that this was a legal impossibility, I'm a little lost on that. Not only was it written in the instrument, but it says it right in the statute that he's citing. And so when you take, the law is you have to take the instrument as a whole. You have to take the trust along with the schedule of beneficiaries. They provided a methodology, and the law says if there's a method, you should follow it. And to say that following it where there are guardians and they're the parents and they're here today, it was a legal impossibility for Jason to contact his cousin. I'm a little lost on that. Part of this instrument too, part of this case is that Mary Jane Gravel wanted to keep it within the Gravel family. And Jason is a maternal nephew. The Gravels lived on the property. So to believe my brother and the ambiguity he's trying to create, that would mean that the grandmother wanted to kick the kids out of their house, and instead of giving the property through the Gravel bloodline, she suddenly wanted to give it outside her bloodline to her maternal bloodline. So the case as a whole, that part is confusing to me. Finally, Your Honor, in terms of whether it be irrevocable or revocable trust, I just want to get back to, you have to look at the trust. What powers did Mary Jane Gravel keep?
I want to ask you about the powers. In the Declaration of Trust document, does she have the ability to disperse, interests of the trust directly to the beneficiaries?
She has the power. When you look at the powers, the general powers, the powers are there to benefit the children, and everything should be done in their best interest. So she has to sell one of the houses if the house needs repair. I mean, this is two-family houses is what's in the trust.
In the trust document itself, what I'm asking, and I'm looking at the scheduled beneficiaries, which the two have to read together. In the trust document itself, she doesn't give her the power to expend the whole or part for the health, welfare, and education of the beneficiary, right?
I'm unclear what you mean.
The Declaration of Trust allows her to manage the property to get the best, to make the best use of the property, to increase the property, but doesn't give her the power to give money to the children for their school or education, right?
I believe that it does. It allows it to do what's in their best interest.
So where does it say that in the Declaration?
Several times in the trust, it says that the trustee is required to do what's in their best interest.
But where does it say that she can distribute the money in their best interest?
So, Your Honor, there were three, what I would call investment, there were 3 apartments that are paying rent. I think the idea of the trust isn't to just keep and let it sit there and accumulate. It's for their benefit. So if we have rent coming in and the children are going to be needing funds, I think the trust can distribute what's their best interest.
So which power A, B, C, D, E, F, G, H, A, I gives her that ability? I'm just trying to understand the document.
I think if you go to B, to sell, assign, convey, transfer, exchange, or deal with or dispose of the trust property, any part, free and discharge. The idea is that it was to benefit the children. So you can't just let the trust sit there and accumulate a ton of cash and not use it for the benefit of the children. The idea is that this was to benefit the children. They were living on the property. Their property was generating income. It was there to be for their benefit. One other last thing I'd like to say, my brother takes exception to the property being dispersed at 25. Your Honor, the trust has to come to an end. Every trust has to come to an end. What Mary Jane Gravel determined is when the children turned 25, they would then get the benefit of the trust, whatever was left over.
Okay, I think we'll have to leave it at that. Complicated case. It's submitted, and that's all we have for today. I want to thank the remaining court officer and the clerks, and we'll be in recess.
All rise.